familiar with my background, most of my background before foreclosure defense was all in criminal defense. I'd had a lot of experience with the Public Defender's Office, both on the East Coast and out here on the West Coast. I think it goes well with the idea of doing foreclosure defense because you're accustomed to being the most hated person in the courtroom. So, right, as a criminal defense attorney, the judge hates you because he wants to put your client away. The DA hates you because he wants to put your client away. And your client hates you because he thinks you're part of the same system that wants to put him away. So you're just very used to, not being the most liked person in the courtroom. You're okay with that. And I once heard that there's nothing worse than a defaulting borrower in the court system, not even a rapist. The only thing worse is a defaulting rapist. You got the worst jokes. So I've moved over. I still have a small portion of criminal cases that my firm does carry. We also do family law and some bankruptcy. We do a lot of bankruptcy because it overlaps to a large degree with our foreclosure cases, in that they may need to restructure their debt, or they may need some time to determine what they're going to do with the property, and so they need to postpone a trustee sale with the automatic stay as part of their bankruptcy. So bankruptcy does become an auxiliary part of our practice to a large degree. At one time, last year, we had about 160 clients, and a large portion of those clients were bankruptcy clients. Now, we're half that, and we have a very small fraction of clients that, for various reasons, determine maybe their overall picture with all of their debt considered requires them to go into bankruptcy. But for various reasons, we do have a small bankruptcy practice. The major portion of my practice at this point is foreclosure defense, and it's mostly title actions. Rarely, if ever, will I get involved with an unlawful detainer, and it greatly depends on the stage at which the unlawful detainers are. But I'll talk more about that in the context of when we discuss unlawful detainers. So my practice is in Alhambra. I practice throughout California, in Northern California, Central California, Southern California, mostly Ventura, Los Angeles, Orange County. I do not take cases in San Diego. I find that the forum is just too difficult, and it's just far enough to be a headache to drive and just not far enough to fly. So, in my practice at least, I found that I prefer to stay out of San Diego. That's a little bit of background about me, and you can read more about it on the introduction page as well as the online sources with regards to my practice, or talk to my amazing business manager who's sitting in the back. He's here and available for any questions during the breaks or lunch, and I greatly appreciate and prefer that he be your point of contact during the breaks and lunch so that I can get my break and lunch so that I can best discuss all of the various topics we have to cover today. So I'm going to jump right in and start talking about some different trial techniques. My firm actually just finished a trial in Chatsworth. It was not a foreclosure case, but it was still a very interesting experience with the courtroom and the various aspects of the things that go into making your trial spectacular. So some of the things you always want to consider when taking your case into trial, and why we start with trial is the holy grail, right? That's the Super Bowl for us attorneys, where you're really going to decide if you've gotten past the judge and you're on to the trial, what's going to be the final outcome for your client and your case law to a large degree, because most parties after a trial aren't going to appeal. Their resources are drained to a large degree, and if it's they're going to want resolution at that point. So that's kind of why we start with trial techniques, and it's also the funner aspect of all of this, so we get to talk about the fun stuff in the beginning and then kind of go on to the meatier parts towards the afternoon. So you want to make sure that your attire is proportionate to your position, in that you want to make sure that you're likable and professional. Those are the two things that really matter in front of your jury and people in general. The more professional you are, the less likable you need to be. The more likable you are, the less professional you need to be. And the ones that have a perfect balance of the two are really able to persuade and are able to get the art of persuasion down to a T. Positioning is really important when you're talking to people and with your jury. If you are a really tall person, you don't want to stand too close to them because you don't want them to feel like you're towering over them. If you're a small person, you don't want to be too far away where they don't feel connected to you. And you don't generally, when talking to people, and you don't want to have the table here that's blocking you from connecting, especially if it's a higher podium, you don't want that to be in between you. When it's a 6-hour discussion, there's got to be some level of, I'm not standing in my 6-inch heels the whole time. I'll definitely do my duties later. In terms of the verbal communication, you want to make sure that you're paying attention to your viewers and your judge, and that you're reading their expressions and you're listening to what he's saying or she's saying, so that you can continue to adjust to the moment as it's happening. You want to make sure that you're rising when you're speaking, especially in federal court, so that you give deference to the bench and to the judge, so that he feels respected and appreciates your position and is able to really listen to what you're saying in terms of the arguments. When you're dealing with your opening statement, as far as trials go in general, you want to make sure that it's simple. You want to keep it simple, you want to keep it simple. And that's the case in your pleadings as well. When you're talking to the judge, when you're talking to the jury, it's a 3-year-old. It's a 3rd grader. Somebody who has a very small attention span, who's used to television with sound bites, and you need to be able to give the judge or the jury or your audience that piece of information in that sound bite. Very short, very crisp. You don't want it to be complicated where it's difficult or challenging to follow, because you'll lose the person and they won't be with you anymore. As far as openings, directs, and closings go, you want to tell a story, and the story is going to be very repetitive. So in the beginning, you're going to tell them what you're going to tell them. In the middle, in the examinations, you're going to tell them what you told them you're going to tell them. And at the end, you're going to tell them what you told them through the opening and direct. And so they're going to hear what your theory is and what your theme is, your theory being what happened, how it happened, why it happened. Again, your theory of the case is how it happened, why it happened, and what happened. And you're going to want to repeat that throughout your trial, from opening to your examinations to your closings, so that when the jury goes back to deliberate, that's all that they're thinking about, is your theory of the case, of your what happened, how it happened, why it happened. Because you've repeated it so many times throughout your opening, your examinations, and your cross, that they can't help but think of it when they go to the deliberation room. So there's a lot of things here that are on the syllabus that you can look over that give you some understanding of how you want to structure the substance and the staging of where you want everything. Again, it's important that you have literary things like structure, substance, staging, something that's catchy, something that maybe has alliteration at the beginning, or the other techniques that you can to help people remember your theme. But it's important that you have it in sound bites like that, so that it's easily recalled. Again, there's some various techniques in here that in cross-examination, this is for the lawyers more than for the homeowners, but it's also important for the homeowners so that they have an understanding of what they can expect from an attorney that they're working with, what they should be doing. Especially in closing, you want to make sure that you're going to impact the opener. Like in the beginning, we want to remember primacy and recency. People remember the things that you told them at the beginning, and people recall the things that you tell them at the end. So things that aren't good for your case, or things, for instance, when you're negotiating with opposing counsel, that again aren't good for your case, are going to be the things you want to slip in the middle that you discuss, not at the beginning and not at the end. You want to pick out your strongest facts, and also always realizing that your trial is going to be reflective of how diligent you were during your discovery process and what you were able to gain from that process and all the facts that you've compiled. You want to make sure that your facts are clear and forceful and are explained in a very clear way. Your jury selection is probably the most key aspect of your trial. You have to make sure that there are people that are going to relate to the issues that you're presenting them with. And one of my favorite questions of all time that I ever heard when I was doing criminal defense in a second-degree murder trial, I was second chairing, and the DA asked, I really, if I recall it correctly, think he only asked one question of the entire jury. And it was a hung jury. I thought he had the harder case to prove, and I think he got it on the retry. But he asked, Well, first he explained who everybody was in the courtroom. So the judge is the person who makes the decisions. The court reporter is the person who takes down all the information but doesn't talk. The jury, deliberates and is supposed to be fair. The sheriff is the one who protects and has a gun. So who would you be and why? It goes through each potential juror. And it just tells you so much, because if they say they want to be the judge and they want to make the decision, then you know that they're an alpha and that they're probably going to have a lot of to say during your deliberation. Versus, in my experience, most people always say they want to be the court reporter. They don't want to talk, they just want to follow. Like, it tells you a lot about, and it's just something easy to break up kind of the hardball questions that you get throughout jury selection. And it's a little more engaging, your jury will like you a little bit more, and that's always the key. You want your jury to love you, and you want your jury to respect you. So again, it's likability and professionalism as far as your trials go. Now we're going to move into pre-litigation considerations for foreclosure defense cases in particular. Right, that's why we're all here. We're all here to learn about how the new legislation, SB 900, that was enacted and came into full force on January 1st, as well as the newest case law, Glaske, has impacted the foreclosure defense arena. And so that's certainly going to be the crux and the meat of what we discuss here today. But again, it's important that we get some of these issues that prelude the very causes of action that give us our best negotiation points, so that we're all in the same place as far as what's allowed and what isn't by the banks. So in pre-litigation, the things that you need to make sure that you have obtained so that you can best review a client's file. One, you're going to want the loan origination documents, and you may even want a forensic audit, but again, that's going to be much less expensive than some of the other types of audits that you will need throughout the litigation. So that's probably the least necessary, because you're going to find that your origination causes of action, lawsuits stemming from something that was done wrong when they created the loan, when they originated it, you'll find that you're going to come against time bar issues a lot. And we're going to get into all of that in great detail. But you're still going to want, if possible, if the client already has it, for some reason, maybe they already obtained it and they already spent that money, you don't want it to go to waste. And so you do want to review the file for a forensic audit if it exists. You're unlikely at the end of all of this, after our full discussion, to recommend to a client that they purchase it if they don't already have one. But it is possible if they have one, or for other reasons, maybe they don't have any other issues like securitization or homeowners bill of rights issues. And we'll get into all of those details as to what it means to have those types of issues. But if they don't, again, you're going to want to make sure that they have a forensic audit that looks at the loan origination. And so you're also going to want to get the loan origination documents. So again, we're talking pre-litigation. What do I need to pull? What all do I need to have to really go in and decide these other issues? So you're going to want all the loan origination documents and perhaps a forensic audit. Next, you're going to want a public record of all the public record. Along with that public record, you're going to want a CFLA audit, right? So for anybody who's unfamiliar with what their audits are, their audits look at the chain of title and to see how it was sold on the second market, if it was done correctly, that securitization chain. They can provide you with a securitization audit. So that's the next thing you're going to want to make sure your file has. And now something new that we are maintaining for our files that I will briefly touch on and you can get more information from us about is called arrest report. Arrest report. And it's R as in road, E as in elephant, S as in Sam, and T as in Tom. It's arrest report. And again, I'll go into more detail about it later, but it has to do with loan modifications. It's a similar software to what the banks use to determine if the borrower qualifies for a modification. So it looks at HAM, and it looks at traditional modifications with rate term differences, term rate differences. And again, I'll go into it later. It's not part of the syllabus because it's brand new, so I will just touch on it briefly. at the most opportune point, which would likely be during our discussion of the loan modifications and the Senate Bill 900 implications. So those are the documents ahead of time, and again, you're going to want also in the pre-litigation all the client's financial documents. So assuming, which we don't like to make a lot of assumptions, but more than an assumption, a direction as an attorney that you should be guiding your clients in, as far as my practice goes, is an understanding and an expectation that the likely result of this litigation and negotiation is a loan modification. The probability that they will maintain the premises, the property, with no lien, needs to be explained to them is, next to nothing. If that, the likelihood of that occurring, is at no more than 2%, and I think that's being generous. So that needs to be, I think, made very clear to your clients, in terms of expectations, so that they understand why you're collecting, what you're collecting, and what's its purpose. And so part of the collection process as of, the beginning of the file for information you need is loan modification applications. If they've ever done it before, you really want to know, have they previously applied? Have they previously been given a modification? And if so, what did that modification look like? It's crucial that if they were given a modification, you have that, because that is a new contract. It means that their previous contract is not the controlling contract. So I'll touch again on all of these in detail, but that's the beginning of your litigation, pre-litigation. We in our firm actually have a department that is titled pre-litigation, and it is for clients that are early in the process that may never need to sue. They may only need to negotiate outside of a litigation for a modification. But during those negotiations, if you're doing it on your own, or if you have an attorney, or if you are the attorneys, it's key that you are tracking all of your communications, that you are writing down everyone you are talking to, everything that is being said to you. Because why this is pre-litigation and not simply a company doing a loan modification, because we are not taking the information as to the financials, filling out an application, and sending it on. That's something the client can do on their own. That's just a modification company. No, we are tracking the communications. We are building causes of action so that if we know their rights and we know how to enforce their rights. So if, while tracking the communications, we conclude that there's been some type of violation of SB 900, we now have our lawsuit, and now they move into litigation. And that's what it means to be in pre-litigation versus just trying to get somebody a modification, is that you are tracking them and you are building their case for litigation. That's why it's also key that you're compiling all of this information up front and not later on down the road after the client has fallen through the SB 900 cracks and it didn't work to resolve their dispute there. So we're going to now talk about what is it that every client is dealing with? What is it the same? And this is kind of the spiel I give each client when they come in, and it's consistently the same and correct. So at some point, you took out an IOU, and you said, I owe X amount of dollars. At this point was probably sometime in 2006, sometime between 2004 and 2006 when everybody was taking out IOUs. So you said, I owe X amount of dollars. And you also said, under that IOU, if I stop making payments, it triggers this other contract, this deed of trust that's connected to this IOU. It says, if I stop making payments under the IOU, it triggers this other contract, the deed of trust. And the deed of trust says, this little clause, power of sale clause says, the beneficiary, the person who was supposed to benefit from that IOU and was supposed to get those payments from the IOU, that person who was supposed to benefit and get the payments from the IOU now has the right, now has the power to sell the property, to repossess the property, to satisfy that IOU that's not being paid on anymore, that you defaulted on. That power of sale clause further says you now have the power as the beneficiary or the assignee of the beneficiary to sell the property through the non-judicial foreclosure process. And that non-judicial foreclosure process is, you stop making payments for 3 months, you default for 3 months. And I can record a notice of default. I have to send that notice to you, and now you are on notice you have to make, this default that you've created over 3 months. I got in a heated debate with somebody I had a meeting with yesterday as to the next steps, as to the timetable. So from my understanding, you will, at least in practice, I can say this much, maybe the statute requires more, but in practice, after that NOD is recorded after 90 days, anytime after that, they will record a notice of trustee sale, and the trustee sale will be listed for a date after the notice. Now, I do believe that it's 21 days from the date that they record the NTS, the notice of trustee sale. It's 21 days before they can actually conduct the sale, because they want to make it public, so there's certain requirements to have it as a public sale. However, I do not believe that it's 90 days for it. It is 90 days until they can record a notice of default, and it is anytime after that that you will receive the notice of trustee sale. There was some debate that it also requires 90 days, so a total of 180 days before sale, but as we all know, that is not in practice how it is done at all. So you get 90 days for the notice of default, and then anytime after that there's a notice of trustee sale, and 21 days after the notice they will attempt to conduct a sale. Now you will find that the sales are routinely and continuously postponed, month after month, year after year, property after property. The reason that's occurring is because the servicer is driving the bus. So what does that mean? It means that you've got the borrower, you've got the investor, and you've got this middleman, the servicer. And the borrower pays the servicer collects the money and gives it to investor. In that scenario, the servicer gets a small fee from the investor. There's not a lot of money in that transaction for the servicer. But the servicer is the one who controls everything, the modifications, the whole system. The servicer's driving the bus. So the servicer can get a whole lot of money while the property's in foreclosure. For as long as the borrower and the property are in foreclosure, the servicer can charge the investor all types of fees. Appraisal fees, maintenance fees, borrower fees that they don't get unless the property is in foreclosure. And at the same time, they are billing the investor for those fees. They are billing the borrower for those same fees.
Hey, Stephanie Johnson here, and I just wanted to say a quick thank you to Fraud Stoppers for helping me to sue for mortgage fraud at the last minute. They helped me stop my home from going into foreclosure, and I'm currently negotiating with my bank for a principal reduction, and it looks like they're even going to forgive me for all of my late payments, which is over $28,000. Trust me, if I could have afforded it, I would have paid them way more than the $1,500 that they charged me, because all the help that I got was worth every penny. So thank you so much, Fraud Stoppers.
And they're racking up the default amount, i.e. keeping them in foreclosure. And so at the end, they're able to claim a larger loss because the debt was higher and they didn't get to collect it, which is what they want to do to drive up their books in terms of the IRS and taxes. And at the same time, they're literally getting more capital from the investors. Now, what's curious about it is that and it ultimately results in more defaults to keep the property in foreclosure for that long, because again, it's driving up the default amount while it's driving up the fees that are associated with the regular default amount. But along with all of that, so the servicer is the one who wants to keep the property in foreclosure. It's why you see the property stay with these trustee sales for so long before they actually go through. And what's curious is that you'll find in one person's loan file, the investor, is Chase and Bank of America is the servicer, but in the very next person's file, it's the opposite. So seemingly, as long as the money is transferring back and forth between the banks, they're okay with it. It's only to the extent that the property stays with the borrower and the borrower keeps the asset that the banks are not okay with it. Because to some degree, Bank of America is ripping off Chase with this as a servicer in loan A, and then Chase is ripping off Bank of America as servicer in loan B. But they don't seem to care so much about that. Now, it's really key and crucial that if you're going to fight about title, that if you're going to file a lawsuit over the property, you do it before the trustee sale. Because once you have a trustee sale, there is a presumption that if there was no suit prior to the sale, that there's a presumption that the person who bought it, it's rightfully theirs. That presumption goes because they're a bona fide purchaser. On the other hand, and it's an irrebuttable presumption, if there's no lawsuit prior to the sale, if there's no lawsuit prior to the sale, then it's irrebuttable that the person who purchased it, if they did so for money, if they weren't the bank, irrebuttable presumption, meaning nothing you put on changes that fact, they're a bona fide purchaser. Irrebuttable presumption, they're a bona fide purchaser. Irrebuttable presumption, they get the property at the end of the day. So it's crucial, again, if you're gonna fight about title, that you fight about it prior to the sale, and that you record a document in the Corporate County Recorder's Office that I'll go into more detail about. But it's key that you record that document prior to the sale, letting everybody know in the public that there is a lawsuit pending, that there is something wrong with this title. Now, there is a presumption when this third party purchases it, or the bank purchases it back, that it now belongs to them, but that presumption is rebuttable. You can present evidence that there was a less pendants and that they knew of the improprieties of the title, and so it's crucial, again, if you're going to fight about title, that you do it prior to the sale. Again, it makes the title unmarketable. No title insurance is going to want to insure a title that has a lawsuit attached to it. No third party is going to want to purchase a property that has a lawsuit attached to it, because they don't want to get added into the lawsuit. Now, when I say never, I mean 0.01% of the time. It does happen in very particular circumstances with very particular people. But in general, 99.9% of the time, if you record a less pendants, the bank will not go through with the sale, because the bank doesn't want to just buy it back. The foreclosure trustee, who's handling the sale of the sale, who's entrusted to handle the sale, does not want to expose itself to liability only to give the property back to the bank. So again, reporting a less pendants prior to the sale will likely stop the sale. So you haven't paid on the IOU. It triggered this clause. This clause allowed a notice of default to be recorded after you didn't make 3 months worth of payments. The servicer probably kept you in foreclosure for a really long time and now has a pending sale. And if you want to fight about that title, you have to do it prior to the sale. Because you're dealing with two issues. You're dealing with the issue of who owns the property, and you're dealing with the issue of who has the right to be in the property. In our scenario, where you're prior a foreclosure sale, possession is not an issue yet. So there are two different issues you're dealing with, the issue of title and the issue of possession. You can imagine a scenario where you own the property, but you've rented the property out to somebody. So although you have title, you no longer have the right to be in the property. You no longer possess the property. Your tenant does. And although the tenant, as in possession of the property, has those possession rights, they're not on your title, so they're not in any way do they have an interest in ownership. So you're dealing with two different issues, ownership and possession. So we're not even on the discussion of possession yet, just looking at the issue of who owns the property, who's got the title to the property. Again, you own it because you're on title, but you have a lien on it. You've got an IOU on property, so there's a presumption at this point prior to the sale that both the bank and the borrower own it. Now, the borrower has defaulted under the IOU and stopped making payments, and it's triggered this other contract, the deed of trust. And the deed of trust has allowed, under this power of sale, the person who was supposed to benefit from that IOU to come in and go through the non-judicial foreclosure process. Record an NOD, a notice of default, 90 days after they've stopped making their first, they missed their first payment. And then subsequently they record the notice of trustee sale and they hold a trustee sale. If you're gonna fight about who has the right to own that property, then you must do it if you want a real chance at winning on the issue of title prior to the sale. Because at that point there is a presumption that both the owner, the borrower, and the bank own the property. But after that sale, there is a presumption that if it is a third-party purchaser, that they are a bona fide purchaser, and that presumption cannot be rebutted with any evidence. If you've recorded the les pendants and notice of the lawsuit, then you can rebut that presumption, and you can present evidence to show that they are not the rightful title owners. So let's talk about what that means to file a title action. Now we're going to discuss the procedure of that very issue of title when you file a lawsuit, and then we're going to discuss the issues of possession. So we're still on the issue of title. I do want to just briefly say, it's important that you have techniques, either non-litigation or litigation techniques, to delay these trustee sales. If they're not willing to on their own because the servicers aren't making any more money at it because it's been a couple of years now and they can't charge any more fees, now they may really want to go through with the sale. You have to have delay techniques in place so that you can, through non-litigation techniques, try to negotiate for postponement. You want to make sure that you have a third-party authorization if you're calling on behalf of the client. That third-party authorization needs to have their social security number, the last 4 digits. It needs to contain all the identifying information of the loan, property address, loan number. You need to make sure that you're authorized to talk to both the servicer and the foreclosure trustee. So along in that deed of trust, along with that power of sale clause, it also names all the parties. In that deed of trust, it tells you who the original lender is. It tells you who the original foreclosure trustee was, and then you have to look to the public record and see if there were any substitutions of trustees, and then you will know who your foreclosure trustee is. Or if there's a notice of default reported, it's going to tell you on there who your foreclosure trustee is. You want to make sure that you have a third-party authorization to speak to both that foreclosure trustee as well as the servicer. Again, your deed of trust is going to name all your parties. It's going to tell you who your original lender is. It's going to tell you who your original foreclosure trustee is. And then you're going to look to the public record. And you're going to see in the public record if there are any substitutions of trustees, as well as look at your notice of default and your notice of trustee sale, which will identify for you your foreclosure trustee. That's the person who's entrusted to oversee the foreclosure process. That's the person who's supposed to be independent. Unfortunately, you'll see that Cal Western Reconveyance is a subsidiary of Wells Fargo, and Recon Trust is a subsidiary of Bank of America. So in no way are they truly independent as the trustee is supposed to be. But that's not really an issue that gets raised with the court or has any traction with the court. It's just one you should be aware of in terms of how the foreclosure trustees are functioning. Your clients are going to get a lot of advertisements that there are companies out there that are able to postpone their sales. They're not going to know that they're advertisements. They're going to think that they're official documents because of the way that they're designed to look official. If your clients email them to you or ask you about them, it's just important that you know what they are so that you can advise them that they're simply advertisements And if you usually look at them pretty closely, you'll see that there's a phone number that's just, you'll be able to likely tell immediately that's an advertisement, but someone who's not familiar with this type of stuff and doesn't see it every day, to them it's going to look as official as the public record recorded documents that are official. So we're on, I believe, just so we're all in the same place, the second page, so the second page on the back. So now we're going to discuss, once we've gotten all the information together and we're going to take a case through litigation, what does that mean? What's the overview? We're not going to get yet into the very specific details of a complaint, what all that needs to be in a complaint and what those causes of action are, but we're going to discuss overview as to the litigation. It's going to start with a complaint. It's going to take, at least in my practice, it takes about 14 to 21 business days to compile the complaint, to really gather all the information and to go through it all and to look at all the various causes of action you potentially have. It's going to take about that long. Now, it can be done on a rush basis.
Could I just ask, this is all specific to California state law. We're in Hawaii, and I don't know if anyone else is from another state, but are the details that you're going to be talking about that are relevant here transferable? There's certainly precedents that might be here in California. Are they sort of, one can use that in court as argument or not?
So the way that the case law works is that it's persuasive versus controlling, and I can get into that in detail when we talk more about case law. But basically, California law is controlling in California, depending on where it's been decided and what courts it controls. It is persuasive in Hawaii. So it's a basis to argue to the court that, I will say that from my understanding, and I have very limited understanding of Hawaii law, but my understanding is that there is statutes that give a lot of the same protections that the statute of Senate Bill 900. So a main portion of what we're going to talk about today is the Homeowners Bill of Rights, and that I understand that there's a sister companion statute similar in Hawaii. So you would need to look to see if there was something similar to that effect. But my understanding is that they don't allow certain things like dual tracking. They don't allow you to be in the foreclosure process at the same time you're being reviewed for modification. Again, I think there is a companion sister statute like that in Hawaii, but this is a California-based curriculum, and that's in large part because it's CLE, it's California Continuing Legal Education, and so for it to be considered continuing legal education, it has to focus primarily on California law. Some of the case law that I'll discuss is not from California. There was case law before Glassky, before Senate Bill 900 that is still persuasive. Ibanez, was one of the major, landmark cases that I'll discuss briefly that does have applicability in Hawaii.
And there's just one more. I'm sorry to ask any questions, but it just intrigues me that it's not arguable that there's a conflict of interest when you've got so-called trustees like representing Lloyds who are actually allied. I don't see why that's not arguable in court as a conflict of interest. The court just dismiss it as
right.
Not relevant.
So I'd like to get through the discussion today, and then we'll hold a Q&A towards the end.
But that's just established, is it, that it's not arguable as conflict of interest? You said it wouldn't hold in court.
You have to look at it practically versus theoretically. I mean, theoretically, there may be some basis or some case law that supports, this being improper, but practically, judges don't take issue with it. The judges practically don't take issue with much of anything at all because they're much, part of the same system in that they're, especially in state court, their pensions are in the defendant's accounts. So you're limited on how much they want to rule against the defendants. So you have to come with very specific arguments in my experience, my practice. So I don't mean to cut you off, but I do want to keep the questions limited to very specific things that need to be said now, because a lot of the questions that I anticipate people would ask at this point will be answered throughout the lecture. So if I'm able to get through the material, then you may have the answer along with everybody else at the same time, kind of in the way my brain thinks. Otherwise, I'll get jumping around from topic to topic. So the timeline is this: 3 to 4 weeks are in, and you've compiled all the necessary information during your pre-litigation. If they've been a client for some time and they've been going through your pre-litigation and you've been going through a loan modification application review process with them, then you likely could do it a lot quicker because you've already got a lot of the information that you need to compile the complaint. At times, you'll find that your non-litigation techniques, your negotiating with foreclosure trustee, we've especially found it to be the case as of recent, is not working as much to stop the sale. And so you need to request a restraining order from the judge. And that's always possible when you're filing your complaint. You can also file an ex parte request for a temporary restraining order, requesting that the judge restrain them from foreclosing on the property while the litigation is going. Typically, you can get the restraining order granted, but that's only going to be for 2 or 3 weeks until they can have a preliminary injunction hearing. At which time they are going to almost certainly, if they do grant the preliminary injunction, also want a bond. That bond may preclude your client. Your client may not be able to pay that bond and your legal fees, so it's the same as them denying the order. So you need to be very conscious and careful strategically about when you request a temporary restraining order in light of the fact that you may either, one, be denied your preliminary injunction or be granted it with some high bond that you're unable to have your client pay. Also be conscious that you don't want your client throwing good money after bad money. This property is majorly underwater, and some of them aren't anymore, so definitely be cognizant as to whether or not the property you're dealing with has equity in it or not. But assuming that it doesn't, like most properties still don't, you're not going to want your client to put up a $10,000 bond, a $5,000 bond, if ultimately, one, they may not keep the property indefinitely, or two, even if they did, they would owe, even if it was just if it was a reinstatement, what they would owe would be so substantially more than what they could ever, gain from the property. If there's no equity, you don't want to throw good money after bad money. It's always a cost-benefit analysis. You want it to cost them less in litigation fees than it would to live in a comparable place. If it cost them $1,500 a month in litigation, but it would cost them $3,000 a month to live in somewhere exactly how they were living now, then they're $1,500 better off cash on hand. You do that for 10 months for them, that's $15,000 more they're walking away with. You always have to do a cost-benefit analysis and keep that in perspective. You also have to remind them that it's an investment. It was an investment when they were paying the banks. It's an investment when they're paying the lawyers. Investments come with risk. They come with returns. They come with probability. The reason why the returns are so high on these litigations is because the risk and probability of there being no return is also very high.
Hi, I'm Cindy and I live here just outside of Austin, Texas, and I wanted to take a second to say thank you to Fraud Stoppers. I actually filed with Fraud Stoppers a wrongful foreclosure lawsuit after Bank of New York Mellon sold my house, and 9 months later I'm still here. Thank you so much, Fraud Stoppers.
Again, you want to record a 2-page document which attaches the lawsuit over to the title of the property. That's when it's sold at a trustee sale. No one but the bank will buy the property because no one wants to buy the lawsuit. After the complaint is filed, the defendants will have 30 days after they're served to either admit everything, deny everything, or say even if everything you say is true, as a matter of law, even if everything you say is true, we didn't do anything wrong. And they can do that on a whole bunch of bases. And we'll talk about some of them in detail. But they can say, for instance, even if everything you say is true, even if we did all of that, you can't tender, you can't put up the whole balance of the loan of what's left that you owe in an escrow account, so you can't complain about anything we did. Now, there's case law that says there's exceptions to that California-made law, and we'll get into that as well. But those are some of the issues that you're going to deal with at your demur hearing. It's really at the demur stage in foreclosure defense, because you'll find in other areas of practice, demur hearings hold little, if any, value, and they're more of a technicality and something that just has to be done and gotten through. Demur hearings are really where your case is decided, where it's determined whether or not your litigation is really going to result in major principal reduction, because it's just going to put so much pressure on the other side because it's now set for trial, or if it's simply going to continue to make the title unmarketable and you're going to be able to maintain the less pendants during appeal because you've already lost on your first complaint. After that demur hearing, the judge can rule one of three ways. He can say, everything that you've got here, I like, it's good to go, I get what you're saying, it's actually viable legal causes of action, I'm going to let it go to trial. That's your best result. The next thing the judge can say is, everything here, not the way it's written. It could fly, it could work, but you got to rewrite it. So I'm going to send it back to you to do it all over again, and you go through that process again. Lastly, the judge can say, there's just no way you could even rewrite this. You got nothing here. There's no viable causes of action. For various reasons, again, there could be various legal reasons, tender, statute of limitations. And he's going to say you're overruled, the demur is sustained with no leave to amend, and now your only option is to appeal. Although I can say that we've had a lot of modification offers made and accepted while clients were on appeal. So the fact that you lose at the lower court level in foreclosure defense doesn't mean that all is lost. Again, you still run that same cost-benefit analysis. Clearly, the cost-benefit analysis changes if the person is no longer living in the property or if the person is no longer able to rent out the property. Then you're looking at a person who is got to pay the fees of the litigation as well as the costs of the housing. And so now you need to be really sure that the probability that they're going to get some type of monetary reward from the litigation is extremely high. Otherwise, their investment is extremely risky and not advisable. In my practice, and I'll get into this within the next couple of minutes, we're going to be talking about possession and where we are in terms, when you litigate in terms of if somebody's already at the end of their eviction proceeding. My position is that a person who has lost possession or is at the very tail end and is about to lose possession within the next 2 to 4 weeks should not spend fees on lawyers. Because with or without a lawyer, they're going to lose possession in that 3 to 4 weeks. If they're that far into it, that tail end of it, that's really not a place where a lawyer can step in and do much for them. It's a linear line. So you've got a current client who's making payments and is current, and all they want is some different terms. Okay, so all you're working towards is a modification, modifying the terms. You've got the client who's delinquent, who's now in default. Now you need it reinstated at modified terms. You've got the client who's got a sale that just happened. Now you need a rescission of the sale. You need the loan reinstated at modified terms. You've got a client who the sale went through, they've received their 3-day notice to quit, and now there's an eviction proceeding, an unlawful detainer that's been filed against them. Now you need the unlawful detainer dismissed, you need the sale rescinded, the loan reinstated at modified terms. It's a linear line that the farther you move down, the more you have to move back. My position is when you are at the end of an eviction proceeding, right about to lose possession, you are too far down that line to move back. So you're going to have a case management conference where you're going to conference to manage the case and its dates. This may happen over and over again throughout your proceedings. Trial is going to get set about 6 months out from your case management conference. Usually it's not going to be your first case management conference. It's going to be, your 5th or 6th. Typically, they're not going to set your trial until your pleadings are not at issue, meaning that the judge has decided in your favor on one of the demurrer hearings and has set your case for trial. That's typical. Some judges will set your case for trial and continue your trial out if the pleadings are still at issue. It just depends on the courtroom. Always better if your court sets the case for trial, even if it's continued. That's always going to put more pressure on the opponent to come to a resolution than if your case is still not at issue and not set for trial. Even if your case is not at issue, if you can get it set for trial, again, in my humble opinion, I think it puts more pressure on your opponent to settle the case with the looming trial, even if it's not likely to go forward. Because again, there's more work to be done, there's more to be billed to the client, because once the case is set for trial, it requires a motion for summary judgment to be filed within a certain statutory time period. And so, although I don't have that on here, you should kind of add to your syllabus that you have the MSJ, the motion for summary judgment. And that, I believe, frankly, cases so rarely get set for trial. It's happened more recently than it did in my earlier practice, that we rarely have MSJ dates. Maybe for every 40 cases, maybe 15 of them will get set for trial for every 40. And for those that do get set for trial, again, they usually settle much quicker, much easier, because they got set for trial, because you start doing discovery, because they have to do their depositions of your plaintiffs so that they can do their MSJ. But I believe it's about 75 days. I believe it's 75 days, maybe 80 days if it's mailed. I believe it's somebody, between 75 and 80, depending on if it's personal service or mailed, before your trial date. The MSJ has to be served on you, and it has to be heard. That may even be the hearing date, but it's a substantial time before the trial date. And so, again, a lot more work has to be done. It puts a lot more pressure on the defendants, and thereby they're more inclined to settle. So we're going to go ahead and take our first break. We're going to take about 15 minutes, and when we come back, we'll be on litigation, possession, and lawful detainer.
I've got one more question.
Okay, we're going to talk about what happens with possession. So you've been talking and dealing with the issue of title and who has the right to own the property. And now we've moved through the non-judicial foreclosure process where a notice of default has been recorded, a notice of trustee sale has been recorded. Both notices have been sent to the borrower. Usually they're sent certified mail so that the borrower cannot dispute the fact that they were sent and received by the borrower. Now the sale has occurred. Once the sale occurs, there is again a presumption that the new owner is the rightful owner, or the person who allegedly purchased it at this foreclosure sale is the rightful owner. Upon purchasing the property at the foreclosure sale, they'll get something called a trustee's deed upon sale. It's called a trustee's deed upon sale. And this is a deed from the foreclosure trustee upon the sale, indicating that the property has transferred from the prior owner to this new buyer that could very well be the bank. Because again, the bank has a right to this title based on the lien. So there's an IOU that says you owe X amount of dollars. The IOU further says if you default under it, it triggers this power of sale clause. That power of sale clause says the beneficiary can take it through a non-judicial foreclosure process. And now that same beneficiary who was supposed to get the benefit of the note of the IOU will instead repossess the property on what is called a credit bid. They don't have to put up any cash. They don't have to pay any money. They just put up a bid based on the credit that they lent to the borrower and based on that lien that the borrower still has on the property. So again, the bank is not paying any money. They cannot be a bona fide purchaser because they didn't purchase it for value. They purchased it based on the fact that they're owed some amount of money under the IOU. Once that sale goes through, the alleged new owner can send a 3-day notice to the prior owner. And that 3-day notice is a notice saying you have 3 days to get out of the property before you're considered what's considered an unlawful holdover tenant. So now they're saying basically this isn't a borrower who owns the property with a lien. This is now a tenant in a landlord-tenant relationship with this new buyer, either the bank or a third party, who's now alleging they're the owner and this is just some tenant who's holding over illegally. They're unlawfully detaining the premises. And so an unlawful detainer is going to be filed against them. They give them 3 days notice to get out of the property. Excuse me. And if that 3 days they are not out of the property, they will file what's called an unlawful detainer against that borrower that's still in possession of the property. In that unlawful detainer, the plaintiff, who's the bank or this third party, is going to say, we only have to prove 3 things. 1, that we gave them a 3-day notice to quit. 2, that they're still in possession after that 3 days. And 3, that we have a duly perfected security interest. Now, what does that mean? 3-day notice to quit is going to be straightforward. It's probably the strongest, best place you can attack and defend if there's something wrong with it. Some have argued, and successfully argued in an unlawful detainer, that it actually requires a 30-day notice, not a 3-day notice. Prior borrower is entitled to 30 days under the deed of trust, under California statutory law. Certainly, this is where having a tenant, an actual tenant living in the premises, makes a huge difference. If this was a rental property, and there is a bona fide tenant in the property, and we'll talk about later what a bona fide tenant is, but if there is a tenant in the property, then they're going to be at least implicating, if not protected under, Protecting Tenants at Foreclosure Act, the PTFA. And we're going to go into detail for about 15 minutes about what that is later in the discussion. So you've gotten the 3-day notice to quit, you haven't come out of the property, they've filed an unlawful detainer, and now they're trying to prove 1, that they gave you the 3-day notice to quit, 2, that you're in possession. To show that you're in possession, they are going to have someone do a drive-by, go by your house and see if there's somebody still living in the house. And they're going to try to make sure that it's your defendant that's in the house. That person's going to come into court and testify, or they're simply going to have the defendant get on the stand, request that they testify because it's a civil matter, there's no Fifth Amendment rights or anything, and they would simply ask, are you still living in the property? So really the only place to fight them is in the third prong, which is a duly perfected security interest. Most courts are going to tell you, you cannot talk about title in this possession court. Also take into consideration that your title action is going to be filed in an unlimited civil court, meaning you have the ability to get unlimited damages. The unlawful detainer is going to be filed in a limited civil court, where they're limited to $10,000 and in some jurisdictions $25,000. But you're going to be limited in what you can get from a limited court. But they're not really going to be looking for damages. They're going to be looking for possession of the premises. The way the statute has been set up, it is meant for the unlawful detainer to go faster. The title action will proceed in a typical, normal, similar situated civil case. It could take anywhere up from 9 to 12 to 24 to 36 months for you to proceed all the way to trial. Whereas an unlawful detainer, a summary proceeding, at max is supposed to take 6 months, 60 days, 2 months, max. If you really know what you're doing, you can drag it out to 6 to 9 to 12 months. There were some bankruptcy filings or otherwise, but in general, it's going to take a couple of months. It proceeds much quicker. The purpose of that and the reason for that was that they did not want third parties, they did not want banks to use self-help. So it is completely illegal and an entirely illegal eviction for the banks to come in and change the locks, for them to change the utilities, for them to use any self-help techniques to get the prior possessor out is illegal and will lead to much more damages than simply them filing an unlawful detainer and going forward with an illegal eviction or illegal foreclosure. If they go forward with a self-help illegal eviction, you have some very, very strong claims in your title action that should be added in. So if you have a title action and during that title action the property sells at a foreclosure and they start an eviction proceeding, and during that eviction proceeding they in any way self-help or try to intimidate or harass or illegally evict your client by changing the locks or changing the utilities or any type of thing like that, you need to make sure that that's immediately amended and added into your title action. Because again, if you were to ultimately lose possession and you're still proceeding on that title action, your claims for illegal eviction are most likely to get you the most money from the defendants versus all your other types of causes of action have to do with the illegal foreclosure versus the illegal eviction. You have stronger claims for a wrongful, let me take it back. You have stronger claims for an illegal eviction than you do for a wrongful foreclosure or a wrongful eviction. As far as the third prong goes for a perfected security interest, the defendants are going to argue that a duly perfected security interest simply means a trustee's deed upon sale recorded within 15 days of the sale. That will be their argument. That's all you need for a duly perfected security interest. You have two ways of attacking that. The first way you can attack it is by saying, even if that's true, you have to have a live testimony to show that. Under Herrera versus Deutsche Bank, and it's cited in the syllabus under the case law section. What Herrera versus Deutsche Bank says, you can take judicial notice, because this is what they're going to want to do. They're going to want to take judicial notice of the trustee's deed upon sale. Judicial notice of the fact that they're the new owners. You can take judicial notice of the fact that a trustee's deed upon sale was recorded. However, what Herrera says is you cannot take judicial notice of the facts contained within the recorded document. So the date that it was recorded, cannot take judicial notice of that. But more specifically, the language in it that says you are duly perfect, you are a beneficiary. The part that establishes that, especially if it's a bank that bought back the property, the fact that establishes that they're the true beneficiary that had the right to a credit bid, that cannot be established by judicial notice. So they need somebody from U.S. Bank to come in and say, I went to the sale, I purchased the property on this date on behalf of U.S. Bank, I did it for X amount of dollars based on a credit bid that we had a credit line extended out to this client. Because remember that U.S. Bank probably didn't extend the credit line out. It was extended out by somebody else. So that's your first line of attack is, one, they probably won't have a live witness. Okay, now I've done this so many times to them that they bring a live witness.
Hey you, my name is Little Tony, and I'm in the garbage business, as in taking out the garbage, if you catch my drift. Hey, it's not like I'm being subtle here. Now listen closely, cause I got a message for you. Turn on those ear holes. If you're currently experiencing a little difficulty with your mortgage, aka you're facing foreclosure, you got three basic options. Option one, you could sit there like a potato and let them steal your happy little home. You gonna do that? I don't think so. You don't look like a potato to me. Option two, you could sue the bank for mortgage fraud. Now, for option two, you're gonna wanna call Fraud Stoppers because they can show you a proven way to save money, save the moolah, and increase your chances for success. And who doesn't like to succeed? Now, I do have another option that I don't usually bring up. you could hire me and the boys for a little, shakedown action. Or a mock funeral, if you, know what I'm talking about here. Or a real funeral, depending on how far you're willing to go on this issue. But I gotta warn you, option 3, it's gonna cost you 10 large, and it's a risky. I mean, I don't want to mention any names, but the last guy who picked option 3, he got pinched, and now he's doing a dime at Folsom. Not the best place to do a dime. AKA, he's singing the blues like Johnny Cash. And I don't know about you, but I don't like singing. So, do yourself and the family a favor, and call the boys at Fraud Stoppers today. Because when the banks break the law, Fraud Stoppers, they break the banks. Now, get out of here. We're all done. I'll see you around.
Okay, so that's not even an argument. So now you have a live witness, okay? So now they say, yes, I was at the sale, I recorded the deed, trustee's deed upon sale. This is all personal knowledge now, okay? And they all, so now you want to attack whether or not they had a right to be the credit bidder. That is solely going to be up to the judge, whether or not you can attack that. It needs to be a motion in limine before your trial in your UD. Both of these are. One is a motion in limine to exclude any facts contained within the recorded documents as being judicially noticed. It's a motion to exclude judicial notice of facts contained within the recorded documents. It's a motion to exclude facts contained within recorded documents. Don't motion to exclude recorded documents, because they're going to say, no, we can take judicial notice of that. The issue is they cannot take judicial notice of facts contained within. The next motion is going to be a motion to include testimony regarding title. The basis for that is going to be the Milkowski decision.
I must be looking at the wrong places. I can't find Herrera in the current
I'll do. Okay. Let me spell out Herrera. No, I think you're right. I don't think it's in there. But Herrera is H-E-R-R. H-E-R-R-A.
I think it's ERA.
E-R-A. E-R-A. Versus Deutsche Bank. Milkowski is even harder to spell. It's M-C-C-L-A-S-K-Y. Something to that effect. If you Google it, you'll get the right spelling. But it's Milkowski. That's the case that stands for the proposition that if you do not raise the issue of title in your unlawful detainer, it doesn't matter. If the court rules against you in an unlawful detainer and there is a judgment entered against you, whether it be by stipulation or by jury or judge, if there is a judgment entered against you in an unlawful detainer, that is preclusionary evidence in your title action. It means that if they decide in an unlawful detainer that they duly perfected their security interest, that precludes you from later arguing in your title action they do not have a duly perfected security interest. So that's why it's crucial, one, that you raise the issue of Milkowski in your briefing and your motions. Two, that you raise it in your trial, and that if your client is really intent on going forward with this, even if he loses possession, that you have a court reporter at that trial, so that you have a clear transcript of your argument that you're supposed to be able to argue title, because under Milkowski, if you don't argue title, it's being decided for you, even though you didn't argue it. Then you have to take an appeal of the UD on the basis that they did not allow you to argue title issues. Because in general, most courts aren't going to let you argue title. I haven't seen one, even despite Milkowski. They'll use it against us, but they will not use it as a basis for allowing you to argue title in a UD court. It's too complicated, the jury won't understand, it's been too quick, you don't have all the evidence, there's various reasons the court will say, or they'll say for whatever reason Malkowski doesn't apply, they'll distinguish it on some basis, but it's very much so directly on point. I actually had an appeal of a title action where we had lost, affirmed, because they said even if we sent it back to the lower court, you could never win because you had a stipulated judgment in the UD. And under Malkowski, that stipulated judgment precludes you from arguing anything else in the title case. So I can guarantee you that if you do not get an accurate transcript, if you do not argue that Malkowski entitles you to title in the UD, and if you do not appeal that UD decision, it will be the basis for you losing the title action. This is a lot of the reason why I say if a client is in an unlawful detainer and they have already answered and they're being set for trial, the only thing you can do for that client is buy that client some more time and negotiate a resolution for them to walk away in a better way. I always equate it to criminal defense, right? So it's always bad. The judge, wants to send your client to jail. The law is set up for your client to go to jail. Your client almost certainly did it. So the law's against you, the facts are against you. And so the best you can hope for in most situations with that is that you mitigate the damages. So it's not telling your client you're not going to jail. It's telling your client you're not going for as long. To some degree, it's the same way with your borrowers. It's not telling them that they're not losing the property, but it's telling them they're not losing the property for X amount of time with nothing. They're getting some type of larger cash for keys. A lot of the time, when you're dealing with a client that's deeply into an eviction, you're hoping to build some equity back into the property by maybe initiating the title action, making the property unmarketable, so even if they get possession, they can't get title right away, and now maybe there's some $5,000 to $10,000 value in releasing that less pendants, and your client gets some nominal amount of money. Something in some degree is better than nothing. However, if it's going to take your client $10,000 to build up that case, then even if you can get him the $10,000, he's breaking even. There's no point. It has to be a cost-benefit analysis. Again, if the client is very far down the eviction road and trial is looming, there's very little that an attorney can do, and it will cost them so much that they're most likely best off walking away from the property at that point and negotiating something with a walk away. Now, I've had clients that came to me post-foreclosure that didn't have a UD filed against them yet, or had just had the UD filed against them, and we were successfully able to get the UD dismissed, to get the sale rescinded, and the loan reinstated at modified terms, or we're in the process of getting the loan reinstated at modified terms. That has happened. I have been able to do that, but it very much so. Once the UD has been filed and an answer has been filed, that means that a lot of the techniques that I would have used. So, for instance, when they filed the unlawful detainer, you may want to file a demur to their unlawful detainer, because that will get you about an additional month. They may advance that hearing, but it at least get you a couple of weeks. So you want to file a demur to their unlawful detainer. If your client wasn't properly served, you want to file a motion to quash service. That can buy some additional time. You want to file motions to consolidate in both your title action and your unlawful detainer. Hail Mary, you might get that granted. There's about a 2% chance of that, and if you do, you're going to skyrocket the value of that particular case. But even if it's not granted, again, it will take additional subsequent time to get past those motions, and during which time you can be negotiating for rescission. A lot of our rescissions and unlawful detainers being dismissed have come because we had a title action going, we filed our motions to consolidate, and we just bogged them down in the UD so much, it dragged on for so long, they just decided to get rid of it. That was better than responding to our 30 discovery requests that we did in the UD. And that's another technique you can use in the UD. You just want to paper them. Just like they paper us, you want to paper them. You want motions to consolidate, you want, I think I list some of them out here, but you want motions to consolidate, you want to make sure that you have motions to quash, and that you propound discovery, you paper them, you do everything you can to bog them down, and that will, in a lot of instances, get them to back off on the UD. Now, if you lose the UD and you're really fighting the fight, you're going to want to appeal, and then you're going to want a motion to stay the judgment pending that appeal. That the judge, you're gonna basically, so what you're doing is you're going back to the same judge who ruled against you in the trial and saying, you got it wrong, now stop from proceeding with what you got wrong till I get you overturned with the people above you to tell you that you're wrong. So he just told you you're wrong, and now you come back and said, no, you're wrong, and while you're wrong, stop from what you're doing so I get the people above you to tell you just how wrong you are. He's not going to do that. So when he doesn't do that, then you can take a writ of mandamus, okay? That writ of mandamus is an emergency of immediate appeal to the court above him saying, not only did he get the trial wrong, but when I asked him to stop from evicting these people while we figured out, and you told him he got the trial wrong, he said no to that. So now really, you gotta tell him he's wrong real fast. And that's what you're doing. So you're filing a motion to stay pending the appeal. And it's also largely based on, factually, the immediate harm, irreparable, meaning you cannot repair it, harm that's going to come to this borrower. Especially if you have a disabled child in the house, if you have someone who's elderly, if you have additional extraordinary facts that mean something, Now, if they've been in the property for 3 years in defaults and in litigation, and they haven't been making payments for 3 years, a lot of courts aren't going to be sympathetic to the idea that they haven't had a lot of notice that they were getting evicted. So that's something to also take into consideration. If for some reason the process went really fast for this particular family, they didn't have a lawyer involved right away, and so maybe they defaulted 3 months after stopped making payments. The sale occurred a couple months later. You're only, if you're 6 months after their default or 8 months after their default, that's a good case for a motion to stay, where there just really hasn't been a lot of time to adjust. Or if it's a dual tracking situation, where they really thought they were in a loan mod review and all of a sudden they were foreclosed on, and so it was just very sudden. You're going to have a better chance at a motion to stay on a very sudden instance. We're going to hold all the questions.
But this is about what you said. You said there were 2 motions in limine that you only gave one.
No, so there's a motion in limine. I'll give them again. Motion in limine to exclude evidence of facts contained within recorded documents. That's the second. And the second one is a motion to include evidence of title to speak. Especially if you have a pending title action. You want to get that in. You want to get in the fact that there's a recorded less pendants. You want to get in the fact that, especially if it's a jury trial, that will make a difference to your jury. If they are asked, did they duly perfect the security interest, and you can show them that there's a dispute over who's got title, your jury's going to understand that they don't have a duly perfected security interest. No problem. You can get a jury in UD. All you have to do is post your jury fees upon getting the unlawful detainer, and you're certainly entitled to a jury. The thing about jury, it's strategic. It's another tactic to drag out your unlawful detainer because it's going to be harder for a court's calendar to get you a jury. Also another thing with that, when you have your demurrer hearing, when you have your trial, any type of hearing, if you have a motion to consolidate, but really your trial, if there is a commissioner, you can always not stip to the commissioner. You do not have to stip to the commissioner. Now, I used to tell my clients, it's going to make the judge hate you, the courtroom's going to hate you, and they're like, well, they hate me already. Can they really hate me anymore? The truth is they probably really can't. So, in most instances, if the client, again, is really bent on fighting about the property and not walking away, understand that the longer your client fights for the property, the less money they're going to get on a walkaway. So your client has to clearly understand, and it has to be explained to them, that if you want more money when you walk away, then you walk away earlier. The longer you stay in possession, the longer you stay clouding the title, the less they're going to want to give if you do ultimately lose and walk away. Again, our success rate and how frequent we're able to get reinstated loans with modified terms has to do with how far down the line they are. If they're current, getting a modification, depending on their financials, is not that challenging. I say depending on their financials because if they can't show a likelihood of defaulting, then it can be really hard to get their terms modified. But if they're in default and they have no pending notice of default or they have no pending sale, that is a prime candidate that you have plenty of time to negotiate for a reinstatement at modified terms, and you'll typically see final resolution. Now, if they're 4 years with no payments, it may just be the sheer value of the arrears that's not allowing you to modify, because and without principal forgiveness, and that may require a lawsuit. With some wins, that gets you set for trial. Now they're really looking at taking off principal reduction. Now you're looking at the ability to get the terms at a place where it falls within the guidelines of HAMP or a traditional modification. As far as our firm, there was a time at which I think we got modification offers maybe once every couple of months, maybe once a month. Now we're getting them pretty consistently 4 or 5 in a week. So I think there has been a huge uptake in the ones that are willing to modify, in their desire to modify, in their ability to modify. There has been a substantial shift since January, since the new laws, since the new case law. It hasn't been overnight. I think it will continue, at least the current swing is towards the borrower. I think, and I sit here every couple of every 6 months or so, and it's always different. I can vividly remember the last time sitting here talking about how much of a swing it was towards the banks, and saying how dismal things had gotten under Gomes and just some of the other case law. And we had hopes for what SB 900 would mean when it took effect. I really think that it blindsided a lot of people that the banks didn't comply more with it. We all kind of went into SB 900 thinking, oh my gosh, now we're really going to get somewhere, and now we're going to have a single point of contact, and they're not going to foreclose on properties that are in modification reviews. And we found that just wasn't the case. And instead, it was, detrimental in relying on them to do the honorable right thing. We weren't filing lawsuits. We weren't recording lost pendants. And so then the sales were still going through on dual tracking, but it was to a third party, a bona fide purchaser, and now, what did I say? You got nothing. You can't rebut. You got a presumption. They got the house. So it's really key that as the landscape changes, that you do not get blindsided or surprised by the fact that even when the law becomes more favorable, even when the statutes become more favorable, it does not mean the banks will continue to comply with the laws. The fact that we're getting more modification offers now does not mean that if they don't find another loophole, they won't take it. Again, for them, it's a cost-benefit analysis. And if it will cost them less to railroad more homeowners, then they will do that. So you have to be cognizant of that as we go forward. I guess we're going to go ahead and start with the state court actions, the causes of action for a state court title action. We are going to talk first about origination fraud, and this is going to be, you're going to find this on we're going to skip bankruptcy for right now, and we're going to come back to that later on in the lecture when we talk more about bankruptcy court and federal court. This part of the bankruptcy is really talking about how bankruptcy affects your state court action, but I'm going to save that for when we talk about bankruptcy in general. We'll come back to it. I'd really like to get to some of the meatier parts. We're going to kind of gloss over origination claims because, again, out of all of them, definitely the weakest of all of the claims. One, because it tends to be fraud. Fraud is one of the few things I've ever gotten to take to trial. It's the only case on foreclosures that I've gotten to take to trial. It was a couple of years ago. One of my clients had been pro per for about 4 years, and she came to me about 4 months before trial, and I took it to trial. It was a servicer case. They had lied to her basically about some servicing aspect of her loan. And the thing about fraud against a big corporation is that you have to prove intent. You have to prove not only did they make a promise about a material term, not only did that promise matter, not only did they break that promise, but here's the one that's just pretty much impossible to prove. They meant to break that promise when they said whatever they said. They meant. They had an intent. To show that a corporation had an intent, you have to have evidence that is very clear. Otherwise, they're going to get some low-level employee to come into court and fall on the sword and say, oh yeah, I did that, but it was just a mistake. It was an accident. I didn't mean to do that. And if you can't prove that they meant to do it, then you don't have a case. Fraud is by far the least favorable, the least desired cause of action to go to trial. If your court guts your complaint of everything else and leaves you with fraud, they're basically saddling your client with $30,000 in costs. Because you're not going to be able to prove fraud at trial, and instead your client's going to not be the prevailing party, and they're going to owe the other side for all of their costs. Not attorney's fees, but costs. And costs to go to trial can get upwards of $25,000 to $30,000. We're just talking about costs. Costs being expert witness fees, regular witness fees, deposition fees, transcript fees, filing fees, fees. Just costs.
Standard proof is higher, clear and standard.
Well, no. Well, it depends on the type of fraud and the various standards. But yeah, I mean, there's a whole slew of reasons why you don't want to end up in fraud. But that is typically what you're going to sue for in the origination of the loan.
Have you ever wondered if your loan contained legal violations or fraud? Have you ever thought about suing your bank for fraud? If so, join Fraud Stoppers right now and you'll get a mortgage fraud investigation and a turnkey federal lawsuit, plus administrative documents, tort letter to stop a foreclosure, tiller rescission letter, loan modification documents, bankruptcy documents, FBI bank fraud documents, and more. Join now at www.fraudstoppers.org/PMA.
It gives you a list of documents here on this first page that you're going to need to ascertain whether or not there were any of these problems with the loan. You're going to want the closing statement, any truth in lending disclosures, any adjustable rate riders, any balloon riders. You're going to want the loan application to determine if they inflated their income. And then they go into some more of these broker fees, loan processing fees. So again, you're going to look at fraud, you're going to look at actual fraud, you're going to look at negligent misrepresentation, fraudulent concealment, so intentional misrepresentation. These are instances where your borrower said, I make $5,000 a month, and then without their knowledge, without their knowing, it was changed to $15,000, and their signature was transposed onto the one with $15,000. That's when you're dealing with fraudulent concealment, when they overinstated their income without their knowledge. Now, you better have a squeaky clean plaintiff, one that's super believable, because otherwise you're going to run into the problem when you get close to the trial date that your client was in on it, that your client knew that it was being overinstated and knew about it and was part of the fraud. That's a problem. The other problem you're going to run up against is statute of limitations. All the things that you're complaining about will have happened significantly longer before you're filing your lawsuit. Somewhere in 2004, 2006, now you're around 2013. Statute of limitations in the best of instances is only going to last 4 years. So your only response to that is tolling, is that the statute of limitations has been tolled. And the basis for that tolling is that your client was unaware. So if they signed it and it said $5,000, how are they ever going to know that it was changed to $15,000 until they defaulted, they got a lawyer, they did a qualified written request, and they got their application back, and they see that the numbers have been changed. So it's really key that you try to see very specific facts here, because just saying that your client was unaware or couldn't figure it out until they got a lawyer, that may get you past your first round of pleadings, but in that amended complaint, the judge is going to want to know very specific reasons and facts for why they couldn't figure out that there was something wrong with their loan. In most instances, most judges are going to say, you should have known when you signed the closing documents that there was something wrong with your loan. That's an appealable issue. So you can still plead it if you have a basis for it. You can still lose on demur, and you can still appeal that, and you can still negotiate a loan modification in that process. Just 1 second. The violations have Business and Professions Code 17200, you're going to see it a lot throughout the causes of action in different various things. You see it here in the instance of robo-signing. That has a lot to do with the fraud aspect of it. Again, not a great cause of action, fraud in general, but BFP 17200, you need actual damages. You need to show that the robo-signer that signed it actually harmed your plaintiff, that the damages actually stem from that signature. And that's very hard because you're talking about a causation issue here, right? So you got to prove, one, that there was harm, and two, that, for instance, in a breach of contract case, that the breach caused the damages. In a fraud case, that the concealment or fraudulent concealment, that the concealment caused the damages. There's a causation aspect. You got to prove that whatever they did wrong is what actually caused the damages. Well, how do you do that when they're always going to come back and say what caused the damage was the default? Anything else is just auxiliary. What caused the damages was the default. Well, but the standard is, and you have to focus the court back to it, isn't the only cause. It has to be a substantial cause. So you have to focus in, if you're going to do a BFP 17200, when you're trying to show actual damages, that the actual damages were substantially caused by the breach or the fraud or the failure to comply with TILA. I'm going to give you a really great example later when we're talking about the Truth in Lending Act 1641G, which is the best cause of action you can have. We're going to go into great detail about it. I'm going to explain how you show causation and you show actual damages. And so when we get to that, it's really key that you understand how that sample works. I don't want to tell it here because it's not really relevant to this cause of action. This cause of action, BFP 17200, if you're going to plead it, you've got to be able to show that the robo-signing was a substantial cause in the damages. Cancellation of contract, you get to cancel the contract if one of the other causes of action is viable. So this only ties to other causes of action. It does not stand alone. Violation of finance lender law is very straightforward. It's got a cap. The loan amount can't be over 417. Most of the loans I deal with at this point are over $1 million, so they're really not going to be covered by the finance lender law. But if they are, then you want to plead that cause of action. Again, it's a statute, so it has its elements within the statute. You got to check the elements, and that's the rule. See if your facts, upon your analysis, you can conclude that there's been a violation of that finance lender law. Conspiracy to defraud. If fraud was hard, conspiracy is impossible. You got to be able to not only show that they meant to do it, but that they all agreed that they meant to do it. Promissory estoppel waiver, it's been okay. It's worked some instances. It's definitely a viable cause of action if you have an instance where a homeowner has been told to stop making payments to be considered for a modification. This isn't as relevant now because they're almost all just been in foreclosure for so long. But in the beginning, it was definitely something the banks were doing the servicers were doing to get people to default on their loans, which was telling them that the only way they could be considered for a modification was if they were 3 months behind. Well, it's just simply, if you have a contract, party A says you no longer have to comply with the terms of the contract for whatever reason, they can't later come back in and then say, oh, but now I want you to start complying with the contract again. So if they're going to tell them that they can stop making payments for any reason, there's an argument to be made that they waive their right to make them make payments later. Intentional infliction of emotional distress doesn't always correspond with the origination claims. It can correspond with any behavior, whether it be in the beginning stages of the loan's origination or if it's in the foreclosure process. You have to, again, look at the elements. Do you have outrageous behavior? Was there a breach? Those types of things. Oral contract is, a breach of an oral contract is not complying with something you agreed to do verbally. Now, typically, you're not going to obviously have a deed of trust that's verbal, as complicated as it is, and it's over, $500. It needs to be, it's a good that's over $500, so it needs to be in writing. But you're going to have maybe changes to the deed of trust that are oral, or maybe promises to postpone the sale. So you may have a breach of a promise to postpone the sale, and so that's going to be a breach of an oral contract. Breach of fiduciary duty is one in which you're going to see, the servicer usually sued for breach of fiduciary duty because the servicer may have had some duty to the borrower to pass their payments to the right investor. So, or if, for instance, the servicer isn't applying the principal and interest correctly, that may be a breach of fiduciary duty. You're going to, again, look at the elements of it. I think we already covered conspiracy to defraud up top a little bit earlier. So now we've gone over origination claims, which is, again, probably the weakest of all the claims and a very small subset of the issues that we present to the court. By far, the most successful and best type of causes of action that you want to have for your suit are servicing claims. Now, within servicing claims, you're going to have SB 900 claims. So you have the origination of the loan, you have an original lender who originated the loan, you have a servicer who's agreed to, quote, service the loan, agreed to collect the payments from the borrower and transmit them to the investor, agreed to collect the payments and apply them to principal and interest correctly, agreed to collect documents for modification. Exactly what the servicer has contracted to do on behalf of the investor is going to be determined by a contract between the servicer and the investor. It's called the servicing contract. There's going to be a master servicer contract, which is not what we're talking about. Master servicer contract has to do with securitization. We'll get there, but that's not what we're talking about right now. Right now, we're just talking about the servicer agreement that the investor has with the servicer for this one particular loan. How has the servicer, Bank of America, agreed with Wells Fargo to service this particular loan? Have they agreed that they're going to have final say on the modification? Have they agreed that the investor has final say on the modification? That is going to be an absolutely, utterly crucial issue to your 1641G cause of action. Again, I'll talk more about that in very excruciating detail after lunch. That's going to be the, securitization as well as the 1641G is going to be the main bulk of our first hour back after lunch. And we're going to conclude this last hour with the bulk of the Homeowners Bill of Rights and maybe a little bit after lunch. Now, so again, the chain is the original lender, the servicer who is servicing the loan, and the investor. There's a few parties in between that we'll talk about during securitization. So far, we have the original lender, the servicer, and the foreclosure trustee. And the reason I keep pointing out who these parties are is because when you're compiling your complaint, you're not just compiling your causes of action. You've got to compile your parties portion too. That's probably the most challenging part I have with paralegals. Who do we sue? We can get them to figure out what do we sue for. You can take a template and run through and add in the names and you understand what to sue for. But who do you sue? Well, if you're suing for origination claims, if you're suing for something that happened wrong at the beginning of the loan, then you're going to sue the original lender. You're going to sue the first people and everybody in the chain afterwards. So the original lender, the servicer, that foreclosure trustee at the end who's trying to foreclose that you got from the notice of default, and the trustee of the securitized trust. And again, we're going to move into that area in a talk after SB 900. So right now, as it stands with origination claims, you would sue the original lender, the foreclosure trustee, the servicer, and the trustee of the securitized trust. It's very important in your language and your discussions and your lingo and your understanding that you recognize there are multiple trustees. And that when you say the trustee, no one knows what you're talking about. Because it's not clear if you're referring to the foreclosure trustee or if you're referring to the trustee of the securitized trust. So it's critical that you identify the party properly, especially in your complaints. Now, you may have a case where it's just an SB 900 claim. That doesn't have anything to do with the original lender. They're out of the picture by that point. And maybe they're current, and so they're not even facing foreclosure. But there's something, they're not being reviewed properly for a modification. They're not being given a single point of contact. Well, then you're going to sue the servicer and the trustee of the securitized trust, because the investor has something to do with that modification as well. But in that instance, you're not going to sue the foreclosure trustee because there's no foreclosure happening. And you're not going to sue the original lender because you're not suing for origination claims. Now, always take into consideration that if you isolate a complaint to only be about servicing claims, and they do have any origination claims, you're foregoing those claims at that point. Because you can't argue that you knew about the servicing fraud, and a year later you want to sue about origination claims, but that whole year you were suing over servicing fraud, you didn't know about what happened at origination. At the point where you start the lawsuit for servicing fraud or servicing errors or servicing issues, you have to bring forward any origination claims you have, or you will be barred by the statute of limitations if you weren't already. So some of the claims you have on servicing fraud. Unjust enrichment, if they're billing you for unwarranted fees or overcharging. So here's where I'm talking about where the servicer is keeping the borrower in foreclosure to bill them on all types of fees. So you look at a notice of default and they owe $60,000. Then you get a debt validation letter 3 weeks later and they owe $90,000. What? That's a problem. That's something you need to look at. There's something there, okay? So anytime you can get debt validation letters, anytime you can get anything, a reinstatement quote, something that shows with 2 different times what they're saying they owe, and if there's a big discrepancy, it's likely because they've added on all types of appraisal fees and maintenance fees that they probably never did. That will usually get you to trial, that'll usually get you into discovery, that'll usually get you a modification. Our modifications that the firm gets tend to range anywhere from $87,000 in principal reduction to $220,000 in principal reduction, to nothing in principal reduction, the best we can get is a reinstatement, to 2 years worth of litigation and we still can't get an offer our client will even consider. It's a wide spectrum. I can't say that there's any one definitive variable that results in one definitive conclusion. I will say in general, it's about people that you're dealing with. It depends on the bank that you're dealing with. It depends on the judge and how he rules. It especially depends on opposing counsel. I find in my practice, female opposing counsels tend to care more. They just tend to want to help more. Innately, they want to help more. And so innately, they desire a resolution, where I don't find that to be as true with male counterparts. So that's something to consider when working with your various opposing counsels. Opposing counsels that I've met in person and I've been able to build a rapport with tend to be more willing to work with me on a resolution permanently for the case. Some counsels are just not happy people, and they're just not happy and don't want to help and don't care. And that's something that you have to consider. Most of what we'll cover today substantively is all theoretical. To a large degree, I try to give you anecdotes to give you some perspective practically how these things are implemented in the day-to-day practice. It's really important that you take away these concepts, the substantive of them, and that you put them to practice in your way that works for your practice to make it as beneficial and efficient for you. Again, these anecdotes are just some things that have worked for me, other things that haven't worked for me. I'm going to get into the securitization aspect. One of the leading cases right now is Jenkins versus Washington Mutual or whatever it was. It was one of my cases. We lost on appeal, It's great to make case law, just not when it's not favorable for your side. But it's just one aspect of the practice. And ultimately, I'll share with you that the client took a loan mod after the decision. I think it may have even been before the decision. And we tried to dismiss the case, and they ruled anyways. But ultimately, not taking it to the California Supreme Court was a decision of my client. And that's what you have to respect in all of this, is that ultimately it's going to be the client that drives the litigation, that drives the decision making. It's key that you keep your clients extremely informed of the changes that are occurring. And so the practice is really 90% client control. That's why I started with clients' expectations are everything to your ability to successfully resolve the dispute at the end. If your client has the expectation of walking away with $300,000 in addition to the property, or even outside of the property, it's unrealistic. The most cash settlements that we've seen come through my office, at least $20,000 walk-away cash for keys. We got a judgment at one time on 1641G. It looks like it's going to be about $90,000, and he's kept the property. That's a rare case that has some learning points from it, but it's not the norm. And so the client has to understand that they're looking at a modification with maybe an interest rate reduction, but it's possible only a reinstatement. It's possible only time being bought. So all of that is important that you explain that to them. Again, servicing claims are the best claims. If you have a violation of 2923.5, you're gold. What is that? That says that the bank has to contact the borrower to tell them about loss mitigation. Now, it does not guarantee them a modification.
Hi everyone, Liz here in Cincinnati to tell you that I applied for a loan modification 8 different times, and each time I was denied. I paid several companies and lawyers, but none of them had any luck to get my loan mod approved. The last time there was a foreclosure sales date set, one of my patients referred me to Fraud Stoppers. To be honest, I had already lost hope and was thinking to just give up, but Mary told me that I had nothing to lose to call them, and so I did. Well, here I am now, 3 months later, to say that Winston at Fraud Stoppers got my loan mod approved so fast that I thought he worked for the bank. Then I learned that he used to be responsible for the entire loss mitigation department for a major bank. No surprise. Thank you, Fraud Stoppers, for helping me to save my home from foreclosure. You guys did the impossible. I owe you one.
You can't touch this. You can't touch this. You can't touch this. You can't touch this. My music hits me so hard, makes me say, oh my Lord, thank you for blessing me. What am I to run and do like you? It feels good when you know you're down. A super dope homeboy from the Oak Town, and I'm known as such, and this is a beat.
It doesn't even guarantee them a review of a modification. It simply means that the bank has a record of showing they called multiple times and told the borrower that they were delinquent. They told them that they could short sell, they told them that they could modify, they told them all of their loss mitigation, and then they signed some declaration. Now, if your client says that they were never contacted, then you can potentially get a TRO. I caution you that if there are phone records or letters and your client is just saying, he didn't receive them, that's not a strong case. And that past demur, you're not going to be able to prove that. You don't want to file things on shaky facts because you can get it past demur, because ultimately there's going to come a point where you're going to have to prove those facts, if not at trial, at the summary judgment motion. Again, you can do BMP 17200, unfair business practices, for overcharging of fees. So again, if these fees are overcharged, the 2923.5 does not work post foreclosure. So if the property is foreclosed on, it doesn't work. It only works pre-foreclosure, and really it's great to try to get a TRO off of. You can usually get a TRO granted off of an allegation that 2923.5 was violated with a declaration from your client saying, I was never contacted. But all that means is they'll withdraw the notice of trustee sale, they'll withdraw the notice of default, they'll call your client, and they'll record the notice of default. So it might buy them some more time and give you some time to negotiate, but ultimately it's not going to be a cause of action that results in you, winning a substantial amount of damages. So we're going to go for about 30 minutes on SB 900. So much to talk about. So much has happened, right? So I kind of want to jump back to what I had touched on briefly, which was when it was first enacted and it was first coming into law, and you can see here when it was enacted in July 2012, and then it was signed, and then it was effective January 1st, we really thought this was going to stop illegal foreclosures, at least the dual tracking aspect. We definitely believed that they were no longer going to be reviewing them for a mod and not postpone the sale. So we had clients in loan mod review, and at the last minute, 2 days before, they were saying, yeah, or the day of, we're going to foreclose now, but we're in loan mod review. So we didn't have time to file a lawsuit and record the less pendants because we were waiting till the last minute on the basis we thought that they would postpone on the basis that there was this new law, and they wouldn't want to expose themselves to the $50,000 worth of statutory damages associated to the statute. Unfortunately, that was not the case for a couple of my clients who unfortunately chose to get services elsewhere because they blamed it on the firm versus recognizing that it was just the banks not following the law. And so once the third party gets involved and you start to lose possession to a third party who's a bona fide purchaser, your resources and your ability to fight that title action are limited. Again, once you lose possession and you're now investing in housing, you're not going to also be investing in the lawsuit on a potential where there's no case law to show one way or the other whether or not you're going to win under this new statute. So in our practice, we still file the lawsuits, record the less pendants. We take no chances at this point. After that first 3 weeks and seeing the way it was happening, we continue to have the same process and timeline that I described to you earlier. We can typically get a complaint filed and a less pendants recorded within 2 business days. We can also have the TRO filed and heard by the court, at least in Los Angeles County, within 3 business days of receiving the file. Obviously, that is the tightest time frame that one could possibly do it on, and requires working past typical work hours. So we always encourage our clients to give us more time than that, and they'll get a better result with more time. This gives you some, background on the law. I think it's really key, and in all of our complaints and all of our arguments when we deal with the SB 900, it's not only, there's not a lot of case law interpreting this. We've gotten a little bit more now that it's been out for what? We're about to be for the whole year. Now it's been about a year, month 11, but it's still very limited. So you have to go back. So if the statute's plain language doesn't give you your answer, and the case law doesn't give you your answer, then you go back to the legislature's intent. It's really important that you contain in your complaints and in your arguments the legislature's intent. The legislature's intent was clear. There were Senate meetings after Senate meetings after Senate meetings. This was meant and is meant to prevent foreclosures. It does not just apply to modifications. It applies to any alternative workout to foreclosure. So that means it covers short sales. That means, and in my practice I've seen, reverse mortgages. It means it covers short pays. It means it covers modifications, cash for keys negotiations, anything that's a deed in lieu negotiations, anything that is an alternative to the foreclosure. I guess cash for keys it probably doesn't apply to, because cash for keys assumes that you're letting it be foreclosed on and you're giving over possession. But a deed in lieu negotiation, I would say, is an alternative to a foreclosure. That's the whole point. You're getting a deed in lieu instead of the foreclosure. So that is an alternative to foreclosure that does have some applicability. Now, it's important that you look at the exclusions. This does not apply to entity borrowers. What does that mean? It doesn't apply to a corporation that's borrowing. It doesn't apply to this is the borderline. There's no case law. Go back to legislature's intent. Legislature says we want to cover everybody we can, so I would say it is covered. But a trust, your client put the property in a trust, and it's now a trust that's negotiating for the modification or the short pay, or maybe there's some argument now that the trust is an entity and not an individual. I suppose it would depend on how the trust was set up, so that gets into very specific details, integrate issues. But in general, you're talking individuals that it applies to. Does not apply to investment properties, rental properties, although I will explain a little bit later in more detail how you can apply it to rental properties under 17200. So if you're in bankruptcy, okay, if you look at this law, the real purpose of this law, the real reason that the legislature brought this law into place was because they were getting a whole bunch of complaints from bankruptcy judges and from bankruptcy courts. The bankruptcy courts were flooded last year with all types of borrowers filing BK to get the automatic stay and then doing the unthinkable, filing an adversary proceeding and trying to void the entire first lien on primary residences within the bankruptcy court. I myself, my firm probably filed 40. I mean, it was really the thing to do, and it didn't work. But it upset the BK court so much so that they definitely wanted, and this was happening before last year. This had been happening for some time, which was one of the main reasons why there was a lot of political pressure outside of the borrowers. I mean, of course, the borrowers were pressuring the politicians to do this statute, but then again, that never gets anything done. So it got done because the bankruptcy judges, the bankruptcy courts did not want the borrowers in the bankruptcy courts. They did not want them filing these adversary proceedings. So as to discourage the borrowers from wanting to be in bankruptcy, they excluded them from being protected by this law. If they're in bankruptcy, this law does not apply. Now, theoretically, it shouldn't be necessary anymore. Because what was the point of filing the bankruptcy? Stopping the trustee sale. But the dual tracking is supposed to stop that. So basically, you had people going for modifications. They were still proceeding to foreclose. BK was being filed to stop the sale. But now, with the statute, it was believed that BK would no longer be necessary because the sale would be stopped just because of the modification review. The second thing you filed BK after stopping the sale was so that you could file the adversary proceeding and you could get a direct line of communication with opposing counsel. And so you didn't have to go round and round and round and round with somebody inside of the bank. This statute was meant to make there be a single point of contact. Ideally, theoretically, you would need to file a BK to stop the sale anymore. You would need to file a BK to get a direct line of communication with opposing counsel. You would just have a mod review going. You'd get your single point of contact, and you would be able to stop the sale because you were in the review. There would be no pending sale at all, theoretically. It hasn't happened that way. But that was the idea behind the statute. That is why the statute excludes anybody who filed bankruptcy, because it was meant to encourage you that you didn't need a bankruptcy. Now, the reason the adversary proceedings didn't work was because most judges concluded they didn't have jurisdiction. It's these state court actions. It's not really relevant to the estate of the bankruptcy. We're not going to dismiss on the merits, but we're going to dismiss for a lack of jurisdiction. Why was it beneficial? Because theoretically, if they had ruled on the merits, it was a way to get a decision on title while at the same time stopping their ability to repossess the property. Because remember, outside of BK, in state court, you got your title action moving so slow that they lose possession ahead of time. Well, in your BK court, you had possession stopped and your title action moving all the way to the end. But the end ended up, in a lot of instances, simply being go back to state court. So it still got a lot of our clients out of that year where they had no protections and into this next year that we are now with SB 900. So here it tells you who a mortgage servicer is. It talks about what dual tracking is. It tells you what the changes are to the modification process. I'm not going to read over what you already have here. I want to give you more than what's already included in the syllabus. And it tells you the single point of contact. So what I'd like to do is really discuss with you how in practice it works versus theoretically here what it's telling you it's supposed to be. Practically, yes, we see banks willing to postpone sales and cancel them more frequently because of the modification efforts. However, it typically still results in us having to file litigation because in most instances, you don't get a single point of contact. You're bounced around from person to person, from representative to representative, and you still need to sue to get to a direct line of communication who can talk to the person who can sign the paper who actually has the authority to get this done. Practically speaking, so you have the concerns of the single point of contact. They absolutely do not comply with the requirement to re-notice you if they postpone it more than 10 days. You're not going to get a new notice. Occasionally, maybe, rarely, but not. They do not comply with that on a consistent basis. Now, the statute says that's not a material breach. So you're not going to be able to sue them because they didn't give you notice that they postponed it more than 10 days. You can sue them because they don't give you a single point of contact. We also tend to get a lot of runaround, just like we were before. It's critical that you keep track of every time you're submitting anything. Something that became their major defense. What is their biggest defense to SB 900? That you have not submitted a fully completed loan modification, right? That word completed is their saving grace. So what does it mean to be completed? From my understanding, from the case law, from the judges, from my workings with opposing counsels, whatever is in their original request. So whatever they originally request from you has to be fully submitted. Now, if they say something's illegible or you need to submit additional documents or what, that's fine and dandy, and you can continue on with that process. But at the point where you submitted that full application, you are in review. If you were in review, you were entitled to a written denial letter. That's key, because sometimes they will try to deny you over the phone, and you have to tell them that's not allowed. I have a lot of standard policy procedure forms that have been created throughout this process. It's really important that you do that. So I have a standard letter that we send anytime we find that they're in violation of some SB 900 component. Now, why does that matter? And this is critical. Let me reiterate. It is so critical that whatever you've identified they've done wrong, you write it out in a letter, signed and dated, and either faxed or certified mail. Because you have now put them on notice of their transgressions. And only if and only if they are on notice are you entitled to the statutory damages. Right, yes, that's absolutely also really, really important that, you know, you've had this third-party authorization on file with the bank, with both the servicer and the foreclosure trustee, and of course that they're honoring that third-party authorization. It's critical that when you communicate with your clients, and I do monthly updates, so I send an email out to every single one of my clients once a month, just letting them know like what the status of their case is. And I always remind them, or at least I try to, and I've reminded them previously, almost certainly, and my staff all knows, to always send us all notices. If they're getting any notices whatsoever, they have to be on guard to be sending them to you, so that they're not aware of something that you're unaware of. Because despite your cease and desist letter, they will still continue to contact your client. They will continue to mail or call your client. And it's important that you advise your client to just continue to redirect their communications to your office. And your client will do the best they can at that, and you'll continue to manage it on a case-by-case basis. But it is really critical because a lot of the times they will try to indicate that you missed a deadline of some sort on the basis that they never sent it to you, but they sent it to your client. So you're given 30 days to appeal any written denial. Again, if they have denied your client, they are obligated to send it in writing, and you have 30 days to appeal that denial. During that 30 days, they cannot foreclose on your client. If your client is made an offer and your client chooses to reject the offer. Your client is given 15 days from that date of rejection before they can hold a sale. And these are the letter of the law. Practically, they're not followed, and you have to continue to keep the banks following these rules. And the way you do that is by listing out and making a letter of any transgressions, of anything they've done wrong, so that they know what they've done wrong, so that if they continue to pursue foreclosure after they've been fully made aware that in writing that there is a modification in review, then when you sue, your client will be entitled to statutory damages of $50,000. That's what's good about this statute, is that you don't need actual damages. You can have actual damages, but even if you have no actual damages, you can show that you notified the bank of the transgression and that they continued with it, then you have statutory damages. And if you have statutory damages, you also get your attorney's fees and costs. Now you've got a lawsuit worth about $250,000, which means your case will almost certainly settle with a modification. That will not be the client that goes up on appeal or the one that goes to trial. Really important, this statute, it has a right to sue clause. I mean, it's clear from the statute, there's no question that you have the right to bring an individual lawsuit. Some of the really wild defenses I've seen, tender applies. And it's like, what do you mean tender applies? This is a statute. Nowhere in the statute does it require tender. And the case law can't require tender in a statutory situation like that. Again, that case that the judge decided that went up on appeal, client got loan mod, we'll never know. Until somebody else who can't get a loan mod wants to pursue it all the way to the end. Right, there is a lot, well, in general, you'll find that your causes of action, there's something called HOLA, it's H-O-L-A, it's an act, it's a federal act. I'm drawing a blank right now on what it stands for, but it is a federal act that has to do basically with the same issues that the Homeowners Bill of Rights has to do with. And there are a lot of instances where the banks are trying to say that HOLA preempts all of this area and doesn't allow for this particular statute and its requirements.
It stands for the Homeowners Loan Act is all it is.
Yeah. Homeowners
Loan Act.
Oh, okay.
But also federal charter.
Right.
They're all federal banks. And the federal charter against it.
That's certainly what the argument is. I mean, there are certainly counter arguments to that. So you're going to want to make sure that you're familiar with the HOLA and that you're familiar with the counter arguments. In real practice, in real life, outside of the academia, as an attorney, you are aware of all of the arguments. If I went to a pleading, I'd be able to review it. I'd be able to articulate it to a court. You walk around with the ability to, discuss every issue that's raised in your complaint, every issue that's raised in your demur. Unless you're in the encyclopedia, that's not going to happen. But certainly you want to have an overview and an understanding of the major causes of action, like 1641G, like SB 900. It's really, so that we're clear, when you're in your complaints, it's a violation of Civil Code of Procedure 2924 something. It's not really a violation of SB 900. You can phrase it that way, but it's not as specific, it's not as clean, it's not as crisp. We always want to be simple, clean, crisp. We want to point the judge directly back to our rule, which is going to be Civil Code of Procedure 2924 point something based on whatever portion of the statute. whole bill, SB 900, has been codified in the Civil Code of Procedure under 2924. So if you want to see how it's laid out in the statute, that's where you need to go, is 2924. I'm going to get into specifically 2924A6 in the context of securitization and selling. It's actually this little gem within SB 900 that not everybody caught, but it actually says that only a beneficiary or an assignee of the beneficiary can foreclose. We have to talk about, when we get to that aspect, and we can kind of talk about it in this context, to what facts does SB 900 apply? Right, we have our exclusions. It doesn't apply in investment properties. It doesn't apply in bankruptcy. It doesn't apply for people who are post-possession, who've already given up their property. And it also doesn't apply when your client has contracted someone's services solely for the purpose of delaying their sale. So a company who, for instance, grants deeds over 1% of the property to somebody else who then files bankruptcy just to stop the sale, if your client has worked with one of those companies, SB 900 does not apply. They wanted to discourage borrowers from going to companies that were solely assisting in delaying the sale. And so to discourage clients, borrowers from doing that, they precluded them from being protected under this statute. But timing-wise, what if your loan mod was denied in December of 2012, but your sale didn't happen till January 2013? Now, it goes back to the legislature's intent. What did they intend? They intended to protect as many people as possible. So if there's a borderline question there, it goes to the borrower. Because the purpose and intent of the statute was to be as broad as possible and protect as many as possible. And there's an argument that the foreclosure itself is proceeding in 2013. So even though the denial came in 2013, the proceeding itself was still occurring in 2013, and thereby it applies. That's a very factual-based scenario. You're going to have to look at your specific facts and be dynamic about it, and think outside the box as to how you can make sure that it applies. Something that's outside of the box is, so you have an investment property, and you've been doing all the modification paperwork, and now you're right about to be foreclosed on. That's absolute dual tracking. If it was, so there's two ways that BFP gets used here, okay? So you've got a rental property, it's absolutely dual tracking. The argument is, if it's illegal to do it on a primary residence, then it's clearly unfair to do it on a rental property. The same argument goes, if it's illegal in 2013 to dual track, then it was certainly unfair in 2012 to do the same thing. So the unfair business practice aspect, because it's or, it's not and, it's not illegal and unfair. It's unfair, illegal, and there's some third word that's slipping my mind right now. Fraudulent. But there's three certain things that you are not allowed to do. And it's not an and, it's an or. So if it's illegal to do it this year, it's unfair to have done it last year, and there's your violation. If it's a direct violation of 2013, i.e. it's illegal this year for dual tracking, then you can also allege a BFP 17200. It's unfair to do it as well as illegal. So you have a violation of both if it's in 2013 and it's a primary residence. You only have a violation of BNP 17200 if it's a rental property or if it happened in 2012. Now, again, you have to show actual damages. So, I believe in this context it works as well, but it certainly works in the context of 1641G. Actual damages. If you were, and it works here too, so if you were denied your modification because you have too many, or let's give a better example. This is a perfect example. You were denied your modification and, quote, the investor's guidelines won't allow us to modify. So, during that time you're dual tracked and they're trying to proceed to foreclose on you at the same time. You sue for SB 900 violations. If they had not dual tracked you and allowed you to continue to negotiate with them to the investor, basically, at this point you need to go to the investor because they're saying, we can't do it, the investor won't let us. You now need to negotiate with the investor. But you can't because they're attempting to foreclose on you at the same time you're in this loan modification review. Then they're precluding you from negotiating with the right party. The question then becomes, if you were able to go negotiate with the right party, what modification would you have gotten? So this is where the REST report is crucial. You get a REST report. You get a report that says, here's all the financials we gave to the bank where they said investor won't modify. We're going to take those same financials and we're going to run them through our software. And the software is key, right? The software is very clean, like very, very, very good software that's used by the banking industry that, you know, has its own formulas. We can provide redacted versions of the report so you can see what numbers or how they're doing their analysis. But you collect the same data that you've given to the bank, you run it through the REST report, and it kicks back out a modification your client qualified for. You compare that modification to the actual loan. If over the life of the loan the client's going to pay $1 million, but with the modified loan they pay $500,000, then their actual damages of not being able to negotiate with the right party for that modification is the difference of $500,000. That's your actual damages. So how do you get actual damages? You show what you could have actually gotten in a modification if reviewed properly by the right people. This is the loan mod I would get. Look at the document, look at the report that shows what my financials show I qualify for if done correctly. I would have had a modification that over the life of the loan I would have paid $500,000. But instead, over the life of the loan, I'm going to be expected to pay $1 million. The difference are my actual damages. That's what you're actually keeping me from saving by not allowing me to negotiate with the right party under the right circumstances. Right circumstances being compliance with SB 900. That's how you tie it to SB 900. It's easily tied to the causes of action for securitization. It's easily tied to the Truth in Lending Act 1641G because that requires you to give notice of a transfer to a new creditor. So those are obvious ones, right? In that if you're not negotiating with the right party, you can't get the modification that the REST report shows you qualify for if you're not negotiating with the right party. But you can take it to the SB 900 context, which is not only are we not negotiating with the right party, but we're not negotiating under the right circumstances because you're not complying with SB 900. I.e., you denied me, but you didn't give me a month to appeal that denial and negotiate correctly. So by violating SB 900, you're not allowing me a proper negotiation, which is causing me not to get the modification I should have gotten, which causes my damages. It's a chain. You'd rather it be a direct link, so you got to clean it up as much as possible in your individual case and make it directly linked to your damages as much as possible. Again, the 1641G context, the securitization, any cause of action that goes to the wrong person is foreclosing. There is a direct correlation that there's a direct causation that if the wrong person is foreclosing, you're negotiating with the wrong party, which is causing you to not get the modification you would otherwise qualify for. That's your damages. That's the direct link. If you're negotiating with the wrong party, then they are stopping you, they are causing you to not get the modification that you qualify for, and those are your damages. We have a, right, we can provide that information. We have a landing page. Yeah. The great thing about the REST report, and I'll talk about it here in more context because it goes along with your modification efforts, the best part about the REST report is that when clients come to you and say, okay, I've been denied 5 times, how much do I need to make to get the modification? The REST report will tell you. How much do I not need to make to get the modification? The REST report will tell you. What possible rates could I get? The REST report will tell you. Do I qualify for HAMP? The rest report will tell you. Do I qualify for a traditional modification? The rest report will tell you. Great time to have it. You got an offer. Is it good? The rest report will tell you. I got an offer. Is it bad? The rest report will tell you. If you get the idea, with the modification review, the rest report will tell you everything you ever wanted to know as to what this client qualifies for, what he needs to qualify for something different, what expenses he would, how much less or more he would need in his expenses. Now, it's a licensing agreement with the rest report company. So you have their software, you're licensed to use their software. You have to pay them a fee for using each report, but it's great because you can run the report multiple times with deviating numbers within a short time period. So within a few days range, you can deviate the numbers and run multiple reports for the same licensing fee. They don't, so for instance, you make a mistake and you put 10,000 and it should have been 5,000 and you want to rerun it so that they will let you do that without charging you an additional fee for the license.
3 times over a 60-day period.
So we're kind of in the infancy stage of working with, it's an evolving field and it's an evolving practice constantly. The rest reports just, I believe their company is very new. I think they kind of very much so saw a niche and a need that's really gotten bigger since SB 900 came out this year. And so, in my understanding, they've never had a problem getting anybody to agree with the reports, but I think they've been using them more in the context, my understanding is they have more clients that are borrowers that are using them in the context of negotiations. Versus now, lawyers like myself are getting them to determine if how viable they are in litigation. I mean, so far, so my experience is that the people they had using them previously, borrowers, were going directly to the banks to get all the necessary information. Because one, you want to use the bank's numbers. If you use your numbers or what you find from your file, their response is possibly going to be, well, that's because of the numbers you used, you didn't use the same numbers as us. So you want to use their numbers. And what do I mean by that? The things that are factored into the rest report are the delinquent fees, things such as that nature. So how much the delinquent fees are, how much the arrears are. These are not numbers you want to get from your client. These are numbers you want to get from the bank. And so the REST company also has, a list of all the servicers' contact information, which was really helpful for us. And they have a sheet, a one-page sheet of all the information you need to collect to run the report. So you call the bank and you get the information directly. That's really simple. When the file is in litigation, it becomes a little bit more complicated, right? Because you can't call the bank directly. You've got to talk to the lawyer. So various lawyers are taking it. Again, this goes back to your report, how you're working with counsel, how much they want to see an offer, how afraid they are that you're going to use it in litigation. So for instance, in one case, it's in federal court. I kind of had mentioned at the previous motion to dismiss hearing that I had this report and that I wanted to use it in my amended pleading. So that queued the opposing counsel up. So now when I asked for it, I told him it was for the sake of a counteroffer, and it is to a large degree. Because this property, and this is a prime example of where REST really goes above and beyond what you could get for any other client anywhere else. Because this client's property, his debt is over $1.7 million, and he has income. So he doesn't qualify in any way for HAMP. He doesn't have a hardship that's going to put him in a HAMP. So you need a traditional modification because they came back with an offer. He rejected it. He countered, but his counter was more like based on what my friends have gotten, based on what I think the market is supposed to be. And this isn't something you can really argue, that's a valid reason to modify it to that level. So I said, well, let's get this REST report. Opposing counsel's position has really been kind of defensive, worried about how we're going to use it. Ultimately, if he doesn't want to give it to us, and we're in litigation, then you go about it through, whatever stage you're at, because we're in federal court. You're going to go through discovery techniques. You're going to use your formal discovery. First, you do informal discovery requests from opposing counsel, basically, to get the information. Then you do formal discovery requests if you have to. And you want to try to not take too long for this, but also indicate to counsel, to the extent that you block me from this information, you're never going to settle this case. You're never going to get a counteroffer from me. That may incentivize them to do it. If you're on appeal, for instance, and you can't go through discovery, then you send them a qualified written request. But some counsels are very simple about it. And the other thing you can request that your client is absolutely entitled to is a payoff statement. A payoff statement is, to a large degree, and this is what counsel queued me up to. He said, you know, Ms. Scott, I don't want to do the work. I don't want to collect this information for you. But I'll send you a payoff statement because I think that has most of everything you need. Once you collect the information, then you go ahead and enter it into the software and you just hit run and it gives you the report. So I do think that they are going to be very credible. We were already doing this basically, and so to some degree I can say yes, they are credible, they are used in court, but we were doing it through a different company, and that company was all external. So we were, paying that company to run the report, to be the expert witness. Now the REST report allows us to do it all internal, and we can get the client an expert down the road if they need one. So it's a way, I think, for the firm to profit a little bit more from the same work that's being performed. We're going to take lunch. It's 12:01, so I'll see everybody back at 1 o'clock. We'll finish up with our SB 900 discussion, and then we're going to move right into the securitization aspect of it, talk about certified forensic loans and the audits that they produce for us, and then we're going to move on into the rest of the afternoon's topics as I discussed them this morning. Okay?
Yes, the room will be locked. Whenever everybody leaves, I'll close the door.
So we can leave.
Everything will be fine like it is. We'll have a moped back up around 1.
Can we stay in here?
I guess.
Rick, do you know what REST stands for? Welcome back. We're here for the second half of the post SB 900 advanced seminar. So if I could get everybody to join back in your seat set, and we're going to go ahead and get started. Oh, sure. Much better. Much better. All right, so back on the record? No, definitely not on the record. Somewhere in between off the record and on the record. We're going to start with the second half of our seminar today, titled Post Senate Bill 900 and Glass-Steagall. We left off before lunch talking about state court and state court causes of action for our complaint. We already previously discussed the procedural posture of our litigation, and now we've discussed some of the things that we go after the banks for in the litigation, being origination, servicing, and then selling fraud is the last type of fraud and causes of action in their actions that we're going to go over. But before we do, we're going to conclude and finish up with Senate Bill 900. What we've discussed and explained is the Civil Code of Procedure 2924 points, whatever specifically is relevant to your situation, whether it be the single point of contact or dual tracking. It also discusses in Senate Bill 900 robo-signing and the illegality of the practice of robo-signing. Robo-signing started in the era where securitization had already pretty much concluded, and now the banks were being sued for not having done it properly, and they needed to fill in the gaps. So to fill in the gaps of the chain of title that were broken during the securitization chain, they would record documents that had been made in mass by people who had little, if any, knowledge of what they were signing and what they were reviewing. And so that practice of various people on mass scale, anywhere from 500 to 1,000 per day of signing of documents, that they had little to no personal knowledge of what they were signing, they eliminated that practice and gave civil penalties of $7,500 for repeated violations. Again, that's been litigated to a large degree previously before SB 900 under the Senate bill, under the Business and Professions Code 17200. Under the unfair and illegal prong, we've been suing for some time for robo-signing. Unfortunately, we haven't seen a lot of traction. Again, it has a large part to do with, are you able to show actual damages? The other issue that you'll run in with courts is their decision going to be that watershed decision that opens, quote, the floodgates to 40 million mortgages going back to the borrowers? Robo-signing, and a very strong opinion on that was in favor of the borrowers, could have had that effect. Or seemingly that's the fear. And so on that basis, most judges don't want to be that judge that gives back 40 million mortgages to the borrowers based on robo-signing or otherwise. But that's why you want to tailor your complaint to make it as factually specific as possible, so as to take it out of that en masse, huge effect that the judge thinks his ruling may have. If you can narrow it and he feels as though he's just deciding this one case, he's more likely to decide with that borrower than he is to give an opinion that's going to be used as precedent and post his cases over and over again. At this point, we're going to move on to securitization, and we'll discuss, SB 900 more in the context of your questions, so I can answer very specific things that people want to have further information on. So there was a time when I gave these seminars a couple years back where it was an entire case. It was an entire seminar. It was an entire litigation. It was an entire practice about securitization. It was so the hot thing that was in. Just like last year, to a large degree, it was adversary proceedings. And now it's a lot of SB 900. There's always something that's very consistent throughout the field that everybody holds on to that has some viability. Securitization, to give a little bit of background for anybody who's unfamiliar with it, really took off in 2005 when the loans were being originated and bundled immediately thereafter. 2004, 2005, 6, 7 was the height of the securitization. And securitization is where the original lender takes his loan and there's someone else in the chain that bundles his loan, that original lender's loan, with a whole bunch of other loans. Or you can look at it from a different perspective. The borrower has taken out a loan, and the borrower has a loan. And his loan, along with 100 other borrowers' loans, are taken from the original lenders, and the original lender sells them to a sponsor. That sponsor sells it to a depositor, and the depositor deposits the loans into a trust by giving the trustee of the securitized trust all the loan instrument documents. So again, you have the original lender who's originated a loan on behalf of the borrower. You have borrower A through Z. And you take A through Z, or 1 through 50, let's make it simpler, and you've got 50 borrowers all with their own loans. Those loans get packaged together, and now instead of having a face value of $500,000 on the note, it has a face value of $500 million, because it's that 500,000 times 50, or however many you've bundled it with, and now that's what's being sold. The original lender is selling off all of their rights to collect the payments. So they're the original beneficiary. They're the original party that's supposed to benefit from that IOU. And they're saying, I'll sell off that interest, the right to receive those payments, to someone else. That is very different, and you have to understand each party within the chain, than the servicer. The servicer does not have a right to the payments. They have a right to collect the payments on behalf of the beneficiary. The servicer is just an agent for the principal. The principal is the investor, is the trustee of the securitized trust. That is the So you got a chain of how the title is going to move. You got the original lender who's going to sell it to the sponsor. You got the sponsor who's going to sell it to the depositor. And the depositor is going to deposit it with the trust. And they're going to issue certificates out of that trust. And you're going to have a group of investors who are going to buy those certificates on the open market, on the second open market. You're a group of investors that have purchased this bundled set of loans now. So remember, you have 50 borrowers, you've taken all of their notes, you've put them together, and you've sold them off from the original lender to the sponsor, from the sponsor to the depositor, and now the depositor, the custodian who works for the depositor, the custodian has been entrusted to deliver to the trust all of these documents that pertain to these 50 loans that have been bundled together and sold. Once the custodian has all of those documents, he has the trust instruments. The trust property is the physical properties that belong to all the borrowers. The investors now have their investment. Their investment is these certificates that promise them the proceeds from the borrowers. So the borrowers make a payment now, and instead of it going to the servicer and then the original lender, it's going to go to the servicer, who has a right to collect the payments on behalf of the principal, and the principal being the trust. The trust is managed by a trustee. That trustee collects the payments and disperses them to the certificate holders. Why does all of this matter? Because who's paying taxes ultimately on the money that the borrower is paying is the person who's actually entitled to repossess the property. That's why we care. Because you had an original lender who clearly, under the original loan, had a right to foreclose if he wasn't paid under the IOU. But when that original lender sold his interest off, now you have to answer the question, who has the right to those payments, if not the original lender? Because whoever has the right to those payments also has the right to come in and repossess. So again, the original lender sold off their interest. So they no longer need to be paid by the borrower. They got paid by somebody else. In particular, they got paid by the sponsor. So the original lender sells the loan, gets paid by the sponsor. They're out of the game as far as securitization goes. Maybe they did something wrong in originating the loan or otherwise, but as far as securitization goes, they no longer are saying they have a right to foreclose, no longer saying they have a right to collect the payments, and they no longer are entitled to that because they sold off their interest. Now, that is the case even if everybody else down the line also doesn't have a right to foreclose. The fact that no one has a right to foreclose is a byproduct of the bank's decisions in how they sold and transferred these loans. It is nothing to do with the borrower. So if the borrower benefits from the fact that they improperly transferred these loans, that is a byproduct of the bank's decision to not properly do the securitization. So original lender is out the game. Now you're looking at the sponsor. Sponsor has paid the originator, but the sponsor immediately sells to the depositor and gets paid by the depositor. So they no longer hold an interest because they've been paid. Why do they do that? Why would you purchase it and immediately sell it? It's because the only way they could get the tax benefits that they wanted or if they would sell it just this way, if there was, quote, two true sales. If there were two true sales, these sales I'm describing now, from the originator to the sponsor, from the sponsor to the depositor, then it could be considered a REMIC tax, a REMIC conduit, a real estate investment, real estate mortgage investment conduit. REMIC was the easiest way to always refer to it, how we still refer to it, a REMIC. As long as it's a REMIC trust, then they don't have to pay taxes on the gains. So when they buy it at X and they sell it at Y and they make Z, they don't have to pay taxes on Z as long as they do the transaction the way I'm describing. From originator to sponsor, sponsor to depositor, depositor to trust, immediately, just like that, without any retention for long-term gains. So for the gains that the sponsor makes and the gains the depositor makes, they don't have to pay taxes. On the other hand, when it gets to the trust, and the trust divides it up into pieces and sells it off to the investors who hold the certificates, now when the borrower pays the servicer and that money is sent to the trustee of the securitized trust on behalf of this group of investors, the investors do have to pay taxes on those gains. That's what makes them the end player. You follow the money. They have to pay taxes on the gains they're getting from the borrowers paying their mortgages each month that are part of their trust. It means that if anybody had a right to foreclose, if securitization was done correctly, it would be the trustee of the securitized trust on behalf of the certificate holders. The only way they become entitled to foreclose on the property is if and only if the securitization transfer was proper. The securitization transfer is governed by New York trust law. There's a great debate, this is the newest, hottest topic, great debate about whether or not these trusts are governed by New York trust law or Delaware trust law. It is clear from all the pooling and servicing agreements that govern all the trusts that it was a choice of law that the parties made, that the originator, the sponsor, the seller, and the trust, all the people who were a party to the pooling and servicing agreement agreed in writing that it would be New York trust law. And so it is New York trust law. There's simply no debate about that. If it comes up, I mean, it's a case-by-case analysis, but they can't get around the plain language of the contract that they contracted for. Being that it's New York trust law is very clear. For you to have the proper chain through securitization, and the pooling and servicing agreements tracked the language of New York trust law. It's not coincidental that they're the same. They specifically went in and tracked the law so that the contract would basically be just an affirmation of what they already understood the law to say, which was, when you transferred it from originator to sponsor, you had to do it in a very specific way. The deed of trust had to be assigned, and the note had to be endorsed. It's a non-negotiable instrument. It's not cash. Cash, you walk into 7-Eleven and you say, I want to buy a candy bar, and they'll let you buy it. You can give that $20 to your friend, and they're going to let them buy the same candy bar, or otherwise they're going to let them use that $20 bill. And it's because that's a negotiable instrument. A non-negotiable instrument, such as a check, requires that you be the person that the check is made out to cash or otherwise use the funds that the check is for. An IOU, such as the ones attached to all the deeds of trust in California, is a non-negotiable instrument. It requires you to be the person that it's written out to, the original lender, or have an endorsement on the note. So it would have said, pay to the order of Countrywide, but now it would have a line saying, now pay to Chase, now pay to, now payable to, and it would have a signature. That's what it means to have an endorsement. What you have to be very careful of is that this was never done properly. In the suits that you're going to be proceeding in, you may find that at the beginning of your lawsuit in year one, they don't have a note that has these endorsements. And somehow magically, in year 3 of your litigation, as you're deposing the person most knowledgeable in Aurora, you got a note with 4 endorsements. But it's just an additional page that seemingly was never attached, and now it doesn't even look the same as the other note that had the first stamp on it. Now this new note with 3 additional stamps, that stamp isn't even in the same place anymore, and it's clearly just a new document. I mean, that's really crucial that you're analyzing it from that perspective, that they will produce whatever they have to produce to keep that house, and you have to be able to combat that with an expert witness that's going to be able to identify this is not the same note, this is not the same page of endorsements, because it's not just that they have 4 endorsements, it's that they had 4 endorsements at the time that the documents were given to the trust. So for securitization to work, you had to have an assignment and an endorsement from the original lender to the sponsor, from the sponsor to the depositor, from the depositor into the trust. It's just basic common sense here, people. If you want to give your right to collect the money to somebody else, you gotta write it down somewhere. If you want to have the right to come in and foreclose because you have the rights under the deed of trust, you gotta transfer all of those rights and duties with the right assignment. It was just that simple. They just wanted everything in writing. And it wasn't one transfer in writing. Every step of the chain had to be in writing. Has to be in writing. This is what the newest case last week really affirmed, was it said you had to follow New York trust law, because that's what the pooling and servicing agreement said you had to follow. New York trust law says when you transfer the loan from the original lender to the sponsor, you have to have an assignment that transfers the interest in the deed of trust from original lender to sponsor. You have to have an endorsement on the note that says pay to the order of, and it can't be in blank. It was pay to the order of, and you had to say who you wanted to be paid to. And then that person, the sponsor, says, okay, pay to the order of depositor. Depositor says, okay, pay to the order. It doesn't just say, it's written down. Sponsor signs, pay to the order of, pay to the order of, pay to the order of, pay to the order of 4 times till you get to the trust. Assignment from original lender to sponsor. Assignment from sponsor to depositor. Assignment from depositor to the trust. Now the trust has the right to foreclose. Now the trust has the right to come in and collect the payments through an agent, i.e. the servicer. Fine. But until you have those documents, you don't have the right. Not only did you have to have the documents, but you had to have the documents delivered to the trust within 90 days of the closing date. Excuse me, I take that back. Of the 90 days after the cutoff date. 90 days after the cutoff date, you have to have all the documents to the trust. That is the closing date. There's a cutoff date for every trust. Your auditor will determine, and this is where it's crucial, this is the part that the lawyers cannot do, and you shouldn't do, even if you could do it, even if you were trained to do it. You do not want to identify the trust. You want your expert witness from CFLA to run your audit, to identify your trust, and to be able to come into court and testify as a witness. Here's the trust I identified. Here's how I identified that trust. Here's the criteria. Here's the trust cutoff date. See, once you've identified the trust, there's going to be a pooling and servicing agreement that governs that trust. That pooling and servicing agreement is going to tell you every other piece of information you need that you have in your audit. That's where you get all the information that comes into the audit. It's identifying the correct trust, so you're looking at the correct pooling and servicing agreement that you have to have an expert witness for. It's not just having them do that, it's having a live body witness who can come in and testify to it. If you do it and you have to testify, you can't be the attorney and a witness in the same case. It's not permitted. You are not allowed to do that. So if you don't want to get disqualified out of your trial because you have to testify as a witness because you found the trust, you get your auditor. So your auditor determines what trust is this loan in. And there's a lot of criteria to go into that, and that's a discussion for another day for someone who knows that stuff. But I'll stick to what I know.
Jerry here from California. I used this tort letter I got from Fraud Stoppers to stop my foreclosure sale. Then I sued Specialized Loan Servicing in federal court for violations of the FDCPA. It's the best $300 I ever spent. Thanks, guys. You are the best.
And from what I understand, once your auditor identifies your trust, then you can gather all the necessary information from your pooling and servicing agreement, and he'll have that all written out for you in your audit. And from there, you know what your cutoff date is. Based on your cutoff date, you know what your closing date is. Your cutoff date is going to be in the pooling and servicing agreement, and your closing date is 90 days from your cutoff date. Per the pooling and servicing agreement, per New York trust law. Now, your closing date is so critical, it's so crucial, because if they cannot have a live body witness testify that has personal knowledge that the custodian delivered to the trust entity all of the documents for that trust, so it would be 4 assignments, 4 endorsements for every single loan, but really all that matters is your loan, okay? If they didn't do it for every other loan, but they did it for your loan, your judge is going to say they got the right to foreclose. The bottom line is, with every file you're ever going to look at, they never did it. They didn't do it because they didn't want to incur the fees involved administratively at creating all of it. They didn't want to incur the fees in recording all of it. And so they shortcut it by doing something, by putting it on this electronic registration system, this thing called MERS. It's the Mortgage Electronic Registration System. And MERS allowed everybody to allegedly do these assignments from the originator to the sponsor, sponsor to the depositor, depositor to the trust, behind the scenes, out of the public record, basically online in a database. Realistically, they weren't even maintaining them in the way that they were supposed to, let alone doing it in a recorded way where everyone else could check it. The reality is the assignments and the endorsements simply weren't done. This is, again, where the robo-signing came in. When the banks got caught on all of this and got called out for it, they started trying to fill in the gaps by getting en masse these assignments made. The reality is that they couldn't even barely possibly get all of them. So they shortcut it. Instead of going originator to sponsor, sponsor to depositor, depositor to trust, they went original lender to trust. And so they started creating all these assignments in 2009, 2010, 11, into 12, and even now, transferring them from the original lender directly to the trust. That does not comply with New York trust law. That does not comply with the pooling and servicing agreement. In largest part, because it all happened after the closing date. If the document wasn't even created until after the closing date, it couldn't possibly have been delivered and given to the trust before the closing date. That hurt my head. Securitization is one of the toughest areas of this practice. I mean, when you think about things that happen in origination fraud, or you think about things like not doing the loan modifications correctly, it's all very straightforward. Securitization isn't law. It's the banking industry. It isn't an area that your judges are familiar with. They don't get it. As far as they're concerned, they borrowed the money, they purchased the house with borrowed money, and they owe somebody. You have to be able to break that whole concept of what we just discussed down into the simplest, most basic terms. They don't have the right paperwork. It's a technicality, but it is the technical language of the law. Glass-Steagall, the leading case in this area in California, it's an interesting time when you hear people talk about we're in the majority, they're in the minority. There was a time when we didn't have a majority opinion. We didn't have a minority opinion. We didn't have an opinion at all. Nobody knew what to make out of the fact that they had securitized all these loans en masse and now wanted to foreclose on them, and nobody has the right paperwork and who's got title. And the judges are much more educated now on the topic and the issue. People are starting to take sides and have opinions. Before, it was a lot more of, we just don't get it. You have to take into consideration with Glass-Steagall where it was decided. In middle country, Central California, where there's a bunch of farms and it's just a different attitude. In Northern California and Southern California, you're not gonna fare as well. It's not controlling. It's only controlling in a certain portion. You need to be very sure that you understand the difference between it being controlling law and persuasive law. Controlling means they don't have a choice but to follow it. Persuasive means they can look at it, and in many instances, they do outright say, I disagree. But that's okay, because if they want to disagree with it on the record, then you can take it up on appeal. There's a reason why the banks did not try to take Glass-Steagall to the California Supreme Court. It's because they don't want the California Supreme Court to rule on it. Because the last thing they could possibly handle is the California Supreme Court siding with Glass-Steagall. In the same vein, to some degree, they won't let our cases get that far. If you do get to the Court of Appeals, you usually will at some point get some type of modification offer, or they'll attempt to go through with the sale to try to get you out of possession before you can get to that point where you've got a positive decision. Securitization has been, the forefront of the fight for borrowers for a couple of years. So we've got a lot of decisions in this area now across the country, because this wasn't a California issue. This was a a nationwide. There you go. Otherwise, they're thinking about Countrywide and Chase, right? And Wazoo. It's a nationwide problem that we really had our first landmark case in Ibanez, which was in Massachusetts, and it's stated here, and if you view the oral argument, it's really great. I mean, this guy really did break it down into the simplest possible terms, and they got it. We've had some other great bankruptcy cases. I'm not going to go into too many of these in detail. Gomes really set us back for a while. Gomes is a really bad case. There's also Fontenote, although it's been overturned and certain things have, not the entire case. Calvo was helpful. Lona is extremely helpful. Lona deals with, again, Tinder. I'm going to go into detail now about Tinder. So Tinder is a California-made judiciary rule. It's not a statute. It's not federal. It's only in the California courts. What it says is, if you want to complain about, or if you want to sue over anything that the banks have done wrong in the foreclosure process, you have to first tender the entire balance of the loan. You have to put up the difference of what you still owe and what you've paid on the original loan in an escrow account. And potentially, if you lose the suit at the end, the judge could take the escrow account and apportion it to the banks to your arrears, or to your attorney's fees if they were to get awarded attorney's fees and costs against you. So it's always a bad idea, and all the time I practice, if a judge asks my client to put up Tinder, I advise my client to walk away. If the judge says, yeah, you can go forward with the suit, but you got to put up $60,000, you walk away. Especially if it's a rental property or if it's a vacation home. I mean, even if it's a primary residence, it's just not worth the risk at that point. There is a similar case, Lona versus Citibank, that provides some exceptions to Tinder. It's very discretionary, but it is the basis for a lot of our arguments that Tinder does not apply. One of the main things about Tinder is that it was always meant to be applied to a procedural defect. So if you didn't receive the notice of default, or if you didn't receive the notice of trustee sale, something that procedurally was done wrong. It seemed unfair on a technicality to allow somebody to thwart the foreclosure process. However, when something, that would make it voidable, okay? That is different than when something is void. Something is void in an instance where just the wrong party is coming in and the wrong party is trying to foreclose. The entity that is trying to foreclose simply does not have standing. In places where it's not a non-judicial foreclosure and instead you have a judicial foreclosure. In instances where you have judicial foreclosure, it requires the bank to be the plaintiff. The bank has to come in and file a lawsuit like an unlawful detainer in California, but just to even get title, the bank has to come in and file a lawsuit and get the judiciary to say they have a right to repossess the property. What that does is it shifts the burden. It puts the burden on the bank to show, one, that they have standing. And it's mainly in those states that you see they've lost that right unless they have the right paperwork. Basically, it's much harder for banks to control judicial foreclosure states than it is for them to control non-judicial foreclosure states. In judicial foreclosure states, again, it is the bank's burden to prove that they have standing. In a non-judicial foreclosure state where you have to file the lawsuit as a borrower to protect your interest, you now have the burden to prove that they do not have standing. In bankruptcy court, when you file bankruptcy, they have to file a proof of claim. Proof that they have the right to claim some portion of your resources for some debt. Proof that they have the right to claim the property. In that instance, the burden again lies with the bank. And now the bank must show they have standing, that they have proof to their claim that they're entitled to this property. Glassky deals with a couple other really key issues. So one of the defendant's bank's favorite arguments past Tinder was, okay, so maybe the pulling, so you'll find first and foremost, all of the bank's responses will be one of, we aren't even going to get to the merits. And I need to talk about whether or not we screwed up under New York trust law. First and foremost, what we're going to deal with is, it doesn't apply to us. Nothing applies to us. And they're going to figure out some way it doesn't apply to them. It doesn't apply to us because you've got the statute of limitations. It doesn't apply to us because you can't tender. It doesn't apply to us because you're not a party to the agreement. You're not a party to the pooling and servicing agreement. You're not a party to any assignment. So, once we transferred it from the original lender, we divested you of all rights. You just got it. That's it. You got nothing. As soon as we took it out of the original lender's hand, you can't come after anybody. The original lender isn't trying to foreclose on you, and we just distanced ourselves from the transaction from you, so you have no rights. Glassky came back and said, that absolutely makes no sense. The air in here is really dry. It's a lot of talking. Excuse me. Glassky said, and Glassky was great because Glassky broke it all down, piece by piece. Glassky, bullet by bullet, said, closing date matters. If you don't have all the documents by the closing date, you can't foreclose. Glassky said, that's true with or without tender. Glassky said, it doesn't matter if they're assigning to the assignment or to the pooling and servicing agreement, none of that matters. They cited Gomes. They went through and distinguished how Gomes didn't apply. Gomes was saying, and to be clear what Gomes says, Gomes says you cannot come in and challenge Cal Western's right to foreclose on behalf of U.S. Bank as the trustee for the securitized trust. One, it said you can't look at that. You can't ask that question of, is that really your agent? In that same vein, it said, you can't come in and challenge MERS' right to transfer the loan from original lender to trustee, or from you couldn't challenge MERS' right to do something. That's what Gomes stands for. Is that if US Bank says they gave, if Wells Fargo says it gave MERS the right to transfer on its behalf, if it gave MERS the right to sign, that's all you need. You can't challenge MERS' right to do something. You can't challenge MERS' right to sign on behalf of someone else. The person who would have the right to challenge that would be the person that MERS signed on behalf of. That's what Gomes said. Gomes didn't touch on, Gomes didn't address, Gomes didn't deal with the idea that the trust who was giving MERS the authority or getting authority from MERS didn't have the right to do whatever it was trying to do. And that's what Glaske deals with. Glaske deals with what rights the trustee of the securitized trust has. Gomes dealt with the right of MERS to sign on behalf of other entities. And one of the major issues there was, in all of these deeds of trust, it named MERS as the nominee and the beneficiary. I really am trying to touch on all the issues that have arisen throughout the years, even those that really don't have a lot of applicability now. So this issue that I'm going to talk about right now is not one you should proceed in court. It does not get any traction. But it was a seemingly important issue at one point. Judges have disregarded it at this stage. And that issue was all of these deeds of trust named MERS as both the nominee and the beneficiary. And you cannot be both the principal and the agent. It kills the it kills the agency relationship. If you're both the agent and the principal, then there's no agency relationship. You're simply the principal, acting on your own behalf. So to name MERS the nominee and the beneficiary seemingly killed its agency relationship and made it just the beneficiary. It was no longer the agent. But MERS couldn't be named as the beneficiary because per its own charter, it holds no interest in any of these notes. And the only way you can be the beneficiary is if you're the person who's entitled to the payments under the IOU. So if MERS is saying on its own charter, we're not entitled to any payments under the IOU. We're simply acting on behalf of the true beneficiary, either the original or an assigned beneficiary. Then you need to just be the agent, meaning you should have just been the nominee, not the nominee and beneficiary. Very technical, not considered to be an issue. The judges have routinely ruled that that wasn't something that was going to stop the foreclosure. Again, we have lots of areas where, we absolutely had the banks dead to right on violating the statutes, but some way, somehow, they've figured out a way to say it doesn't apply to them. So a violation of Civil Code of Procedure 2932.5. So you had 2923.5, which is still viable, pre-foreclosure sale. But you also have 2932.5, which is absolutely 100% not an okay cause of action. In fact, if you were to sue over that at this stage, you would probably get hit with a motion for sanctions because it is that clear cut from the case law, not a viable cause of action. This statute said you could not foreclose on the property prior to being either the original beneficiary or the assigned beneficiary. So if you recorded a notice of default in 2009, November, and you weren't assigned the rights until January 2010, then that's illegal. How can you try to attempt to foreclose on a property when you haven't even been given the beneficial interest yet? And we know that because it happens 2 months later. Clear cut, across the board, violated. There was one case at one point, and there were cases on both sides that basically said 2930. The minority initially said, and the majority disagreed, and now the majority says, this is the majority rule, 2932.5 only applies to mortgages and not deeds of trust. Conveniently, all we have in California are deeds of trust. So 2932.5, clearly violated, clearly not applicable. Moving on now. And we'll go to one that makes me feel all warm and fuzzy. 1641G. So the Truth in Lending Act, 1641G. You won't get as much traction with this cause of action in state court because it's a federal statute. But in federal court, you will get all the traction. You will get set for trial and you will get judgments. 1641G, and now this is a federal statute, so this would apply equally the same in Hawaii as it does in California. Absolutely across the board. This would be a case for federal court in Hawaii as it would be a federal court case in Illinois as it would be a federal court case in California. What gets you into federal court are two things. You can get into federal court, one, because your dispute is over $75,000 and the people live in different states. People or entities. You know, CalWest is in California, and your borrower's in California, and your foreclosure trustees in Texas. Then it can go to federal court. It's called diversity jurisdiction, where your defendants and your plaintiffs are completely diverse. If you don't file in federal court and there's diversity, or if you don't file in federal court and there's a federal question. So a federal statute such as the Truth in Lending Act, that implicates federal law. If there's federal law that's implicated, then there's a federal question. If there's a federal question, then you have federal jurisdiction. If you do not file in federal court and either one of those exists, the defendants can remove the case to federal court. They must remove within 30 days of receiving the complaint, i.e. they cannot demur and then remove, unless it's on subject matter jurisdiction, and that means, at any time they can remove on the basis of jurisdiction, on the basis of diversity. If all of a sudden 6 months into the litigation you add in a party and that party makes the case diverse, then they could remand it at that time.
Hey, what is going on, everybody? Terrence here in Memphis. Guys, look, I want to give a big shout out to my boys, Fraud Stoppers. I filed a Fraud Stoppers quiet title lawsuit, and Wells Fargo stopped the foreclosure faster than Donald Trump fired the FBI director. Guys, I've never seen anything like this. Fraud Stoppers, man, I owe you guys big time. Thank you.
On the other hand, if they're trying to remand because there's a federal question, they have to do that before they demur or answer. If you have the federal cause of action 1641G, I do think it's advantageous to file in federal court versus state court, because federal judges seem to care more about the banks violating federal statutes than the state courts do. I've probably had a good 6 or 7 or more cases set for trial on this one cause of action alone. Each and every time it has led to either a judgment or a very favorable modification. In one instance, it led to a principal reduction on a Fannie Mae loan, which is very unheard of, and just some really great terms in terms of the modification. And it had everything to do with litigation. So again, 1641G is the best cause of action. Now, what does 1641G say? It says that upon the bank transferring their interest, okay, it's, first of all, and it's really important that you know, it's only applicable after 2009. So after 2009, anytime the bank transferred an interest, the new owner is obligated under 1641G to notify the borrower of the transfer and give the borrower a notice with a list of information, A through G or something, A being the name of the investor, B, its contact information, C, the place of any assignment, any reported assignment, D, it's very specific and very detailed and requires more than just contact information. It requires, I don't want to misstate it here. Yes, it requires the date of the assignment. It requires, so for instance, an assignment, the typical assignments you see in the recorded documents, that's not going to be enough. A notice of transfer of servicing rights, that's not going to be enough. Remember, I specified there's a difference between the servicer who can collect the payments and the investor who has the right to reap the benefit of the payment. So the servicer has the right to collect the payment on behalf of the investor. The investor has the right to retain the payment and actually receive its benefit. They're the beneficiary. An assignment, a recorded assignment, transfers the interest that the investor or that the beneficiary has. It transfers the beneficial interest in the recorded deed of trust. So when you want to transfer the interest in the deed of trust, it's through this assignment. When you want to transfer the servicing rights, the right to collect the payments on behalf of that person who's the beneficiary, that's going to be done through just a standard letter that says notice of transfer of servicing rights. So with that clarification and understanding that you have the notice of the transfer of servicing rights through a letter, and you have the transfer of the beneficial interest through an assignment, and you have the transfer of the note through an endorsement. When you transfer the interest through that assignment, the beneficial interest, it triggers TILA. It triggers the 1641G that requires a further notice to the borrower in very detailed form of the new investors or new banks that has the interest. It requires their name, their phone number, the date of transfer, the person who signed the transfer documents. It has a full set of requirements. If that requirement is not met, so if Bank of America is the servicer and the borrower continues to negotiate with Bank of America under the premise that is its investor, when in fact U.S. Bank is now the investor, and you never told them that U.S. Bank was the investor, and they negotiated all this time with you, the argument is, had they been negotiating with the right party, they would have gotten modification X that you have from your arrest report. And the difference between modification X and what they will pay over the life of the loan is the damages that they will actually incur because they were not able to negotiate with U.S. Bank because U.S. Bank failed to comply with TILA. It all logically flows from that actual damages. There are other actual damages that you can argue. Any loss in equity by these additional assignments. The securitization analysis report itself can be considered a damage that only had to be paid for because they didn't get this Truth in Lending Act notice. Actual damages are key because the Truth in Lending Act only allows for actual $4,000 in statutory and attorney's fees and costs. The reason why I got a judgment on this case was because we clearly had a violation of 1641G. Clearly a violation. They acknowledged the violation, and all we argued over for 6 months or so was the damages. We had some expert reports. They wanted a stipulated judgment. They gave us an offer. The offer was the $4,000 plus attorney's fees and costs. Now, in federal court, if you get an offer and that's the max you can receive at trial, then basically the court will enter judgment for you. So the court determined that we couldn't win anything more than the $4,000 in attorney's fees and costs. So the court entered the judgment against the judgment. The defendants went for motion for summary judgment on the basis that we couldn't get anything more at trial than what they had already offered us. The court agreed with them that we couldn't get anything more than they had offered, and so we got a judgment entered of about $90,000 in attorney's fees and costs. So it was a win in that my client was able to get that along with he's still in the property, and he's now going through a new mod review because the servicers changed during the time of litigation. So one of the main things is always keeping your client in the game, always keeping them fighting, especially at the lower court level, at the trial court level. It's harder to win the battle at the appeal court level, but you can still keep them getting something beneficial out of property. For instance, in that case, the client isn't paying a mortgage and it's a triplex, so he's renting out 2 of them. So he's also increasing his income in that respect. There's a violation of 2934A for a substitution of trustee violations, although the case law has become really unfavorable in that respect, and I don't litigate over the issue of substitution of trustee. I got dinged by a court in one of my cases up north and got sanctioned 20 hours of CLE credit. This is how politically driven it all is, right? So I got sanctioned by the judge to do 20 hours of CLE credit, 8 of which he required to be foreclosure defense. So I taught a couple classes. You gotta love it. California Bar Association seems to think I know it well enough to teach it to everybody else. But the judges, But, I'll give him credit that was better than, what the bank's attorneys obviously are looking to just fee shift and are looking to shift the cost so that their clients aren't the ones paying it. And the judge recognized it as that. But you do run some issues with these arguments with the substitutions of trustees in terms of, how clear-cut you always have to know when you're borderline, when you're up against the line as far as trying to make new law versus trying to get a change in the law. So if the law is so clear-cut like it is on 2932.5, at least at the Court of Appeals level, right? So at the Court of Appeals level, it's clear what their position is, that it doesn't apply to deeds of trust. So arguing at the lower court level that it does is improper, because that's controlling law. On the other hand, if you already had cases in appeal, once these decisions came out, it's totally okay to continue on with the appeals and to try to get the California Supreme Court to say something different than the Court of Appeals. Now, something that's kind of a gem that not everybody has caught on to yet, you have this wrongful foreclosure cause of action now under Glaske. We do it as a 2-step thing. So here's kind of how our complaints read. Typically 4 causes of action. We try to distill it down, and you don't want to throw the whole kitchen sink at them because you don't want to be dealing with, a demurrer that responds to every part of your complaint and an opposition that has to respond to every aspect of their demurrer, if some of them you already know are going to get kicked out for various reasons. So we start with wrongful foreclosure under the basis of the Glaske decision, under the basis that it did not get in by the closing date. Our second cause of action is a violation of 2924A6, which requires that the foreclosing entity be either the original beneficiary or an assigned beneficiary. Now, if they failed to do the securitization correctly under Glaske and cause of action 1, then they've clearly violated cause of action number 2 because they're not the right beneficiary that's trying to foreclose. The only, again, they always go, it doesn't apply. And their logical explanation for why it doesn't apply is that, and it is logical, if the foreclosure started in 2012, then that's pre the enactment, it's pre the effect when it took effect on January 1st, and it's not retroactive. So the argument is that it doesn't apply, but the question is it not the same entity that is threatening to foreclose in 2013? Is that to say then, now that we're in 2013, and this is what you want your opposition to ask for, basically. So is that to say the defendants are prepared to give us a declaration that as of 2013, they no longer intend on foreclosing on this property? If their response is simply, we haven't tried to foreclose in 2013, then your opposition to that needs to be, there's been no formal declaration in 2013 by any representative of the entities. If counsel wants to represent in a declaration on the record that his client no longer claims an interest, then correct, it doesn't apply. But short of them putting that on the record in a declaration that their client no longer claims an interest and thereby no longer claims a right to foreclose, then certainly it applies in 2013 because they are attempting to foreclose. Now, again, if they make that argument, maybe your lawsuit's premature. Maybe you wait until they record the notice of trustee sale or they put the sale back on the list. It's a question of factual timing. if the notice of default was recorded in 2012, but it's now being enforced in 2013, what's the operative date? My logical argument has to be that the operative date is the continued proceeding toward foreclosure in 2013. So, for instance, this cause of action I don't think works for a post-foreclosure case where the property was sold in 2012. The foreclosure was concluded in 2012, so it's not applicable. I mean, now you're just talking about an entity that's trying to evict the person in the eviction proceeding. That's not someone who's claiming, I can see in that instance where a judge would side that it doesn't apply. On the other hand, if the foreclosure has not completed and there's still a pending sale, then the foreclosure is concluding in 2013. Again, the issue becomes whether or not Senate Bill 900 applies in that context, whether or not the operative date is the start of the foreclosure or the conclusion of the foreclosure. If it's and it seems logical that it would be the conclusion of the foreclosure. These are issues that our litigation will resolve through these cases, appeals, and otherwise. But I don't know that there's any case law currently that says, because I haven't seen a lot of litigation over the issue. It's very small. It's one very specific statute. There's one other instance where seemingly it doesn't help you, is if the same original foreclosure trustee is your current foreclosure trustee. So the statute says that it has to be the original beneficiary, the assigned beneficiary, or its agent. So the foreclosure trustee that was the original foreclosure trustee on the deed of trust seemingly is the original lender's agent. So that would seem to be that it was in compliance. So, to kind of say that again, the statute says that it has to be the original beneficiary, the assigned beneficiary, or an agent of one of those entities. If it is the original trustee, is the same foreclosure trustee that's currently trying to foreclose, then that would seemingly be an agent and thereby comply. And again, this is where Gomes comes in that says you can't question whether or not that's an appropriate agency relationship. So after those two causes of action, then we usually have a third cause of action, and it's basically the only one we've stuck with from the origination, and that's that they've set them up for certain defaults. So a breach of the good faith and fair dealing covenant. You have to be careful on how you organize your complaint, because you don't want to be talking about, you don't want it to be disjointed where you're talking about the selling aspect of the loan, and then you jump back into talking about when you created the loan, because the way I just described it is not chronological. So in your factual, setup, so you have your parties, you have your cover page, you have your intro, you have your parties. You want to have your factual layout where you're talking about how the loan was created, and you want the factual aspect to be chronological. So you want to talk first about how it was originated, then how it was sold on the second market, and you're probably going to have some general allegations about securitization there. Then you're going to have your first cause of action, wrongful foreclosure, where you go over all the issues of there not being two true sales, and there not being two true sales, and there being violations of the securitization chain, and therefore a wrongful foreclosure. Then you're going to have your SB 900, violation of Senate Bill SB 900 2924A, where you're going to discuss how those same facts lead to a violation of this statute in the same way that they wrongfully foreclosed. The same facts lead to these two violations. Then you can, because you already set the facts up at the top, talk about how it's a breach of good faith and fair dealing to have set them up for certain defaults and how that cause of action goes. Lastly, you give an alternate theory. So it's inopposite to say U.S. Bank does not have the right to foreclose as the trustee of the securitized trust because they didn't get the interest through securitization. But they violated 1641G because they do actually own the loan and are a creditor. That you can't argue those together. You cannot say they don't have the right to foreclose because they're not the right party in interest, but they had a duty to comply with 1641G because they are the right party in interest. It is an alternative theory. It's like this. You're saying securitization failed, and you have to be very extremely clear because they're going to think especially state courts, think your 1641G cause of action is premised on the transfer at securitization, which is before 2009, when TILA didn't apply. If your judge misunderstands the argument to say that they violated TILA because of the securitization transfer or attempted securitization transfer in 2006, they will say TILA does not apply. TILA did not come into effect in this aspect until 2009. So it has to be made clear. The argument is this. In 2005, 2006, when the loan was securitized, it failed securitization because it did not make it in by the closing date. Therefore, they are not the right party. They cannot foreclose. Period. Judge says, nope, doesn't work. I'm in the majority. We don't agree with Glassman. Okay, that's fine. Fine. Well, then in 2010, when they assigned it from the original lender directly to the trust, it was transferred then. We'll agree. It was transferred then. And because of that transfer, it triggered TILA, requiring them to comply with 1641G and give the notice. It's an alternative theory. Your alternate theory is not as lucrative. It's a stronger theory. It's one judges like to accept more, but it's not as lucrative. The wrongful foreclosure and actual damages from that are going to be much higher and more substantial, and you could potentially keep the property. If you were to go all the way to trial, and I do have one case set for trial on wrongful foreclosure because the defendants filed a 20-page demur instead of a 15-page demur, and the judge overruled it on every cause of action. That's how arbitrary.
5 pages too much.
Right. So the judge is really technical. Whenever somebody files paperwork in his courtroom, Judge True, he just absolutely, you have to comply. Like, one of our motions were denied because we didn't tab the exhibits. Hey, but I'm set for trial in that case. You know, it could be a landmark decision. But those are the issues that you're going to find when you're arguing your various theories. You want to make sure that they're not in opposite of each other. You want to make sure that the judge understands that your Truth in Lending Act is for the transfer on the assignment. If you don't have an assignment in the public record, you don't have a 1641G cause of action. If you do not have a recorded assignment, you do not have a 1641G. If you don't have 1641G, you don't have federal court. The security first rule simply says that they can't, one, try to get the money and the property. It's just that simple. They can't get both the property and the debt they're owed. So, and there's anti-deficiency laws in California on first. So if when they go to get the property, it's less than what the borrower owed, they don't get the difference on the first lien. The first lien can't, again, they can't take the property and then also come after them for the $100,000 that they didn't get because the property's underwater. You can sue for a breach of contract under HAMP guidelines if they just do not properly review them. If under the HAMP guidelines they do qualify, but they tell them they don't. For instance, I had them tell me once that my client didn't qualify for HAMP because it was a rental property. So I sent it off to the expert. Expert came back and said HAMP Tier 2 was specifically just for rental properties. But it's really important that you're working with an expert on modifications because I didn't know stuff like that. Like you're not going to know everything to do unless you're running modifications like we're now doing internally with REST reports. You're not going to know about modifications like that. So you need to be working with someone who does, or you need to be a licensed representative of something like REST so that you're familiar with it. You can do the practice without it. I did it for a lot of years without it. It just makes your discussions with the servicers and with the attorneys more fruitful, better negotiations because they know that you know what they can and cannot do. So you can have a violation of 2924 for the failure to comply with non-judicial foreclosure requirements, i.e. they try to record the notice of default after the first month and it takes 3 months, or they don't send a notice of default to the borrower. The other ones are very self-explanatory. Declaratory relief is good, especially if you're going for that second cause of action and you want, some kind of declaration from the court saying that because they're no longer claiming an interest in 2013, then it doesn't, the SB 900 doesn't apply to them. Because then, if you get them in that proceeding saying they're not the entity that's trying to foreclose in 2013, and then later they come back and try to foreclose, you could bring another proceeding and you can use that as exclusionary evidence for them to argue anything else. You want to make sure, again, in all of your cases that you have damages, and that's really where you're going to get hit really hard. Is that causation issue? Was it the default that caused the damages? Was it the default that caused the bankruptcy? Was it the default that caused? You need to have substantial evidence, an expert witness in particular. This is where the expert witnesses, especially from CFLA, that's where we get most of our expert witnesses on these issues of securitization and damages really comes into play. They're able to get you experts who can talk about the decrease in the property value. So it's one thing to say there was lost equity. It's another thing for your expert to be able to show you how at that time that you're talking about when it was securitized, there's, a 6-month decline in property value there, or for that particular property. If there's a 6-month decline in the operative time period, that's really what's going to matter. Okay, so we're going to move on now. I think we're moving past now Senate Bill 900, securitization, and the TILA, and we're going to go ahead and move on into the federal and BK courts. I touched on them a little bit. I did touch on in federal court, the Truth in Lending Act violation. Federal court, the things you have to be concerned about. It's much, much more strict. Your timing deadlines are much more sensitive. They're not going to cut you slack the way the state courts are about any type of omission of information, or they're just simply more strict, and they're not going to give you oral arguments. If you're getting oral arguments, not a good sign. It usually means they're confused about something, or you left something out, or it's only in the instances where they need clarification on something that they don't quite understand. That's the only time they're going to ask for oral arguments on a motion to dismiss, for instance, which is the equivalent of a demur in federal court. So it's good in that less of your resources are spent on appearing in court. It's not great in that you don't get that opportunity to persuade, so your written analysis has to be crisp on your federal cases. They are much less inclined to grant continuances. In fact, they won't grant continuances even if the pleadings are not at issue yet. As soon as as soon as they set trial, be fully aware, as soon as they set trial, you are to start doing discovery. You don't wait until the pleadings are set. And to say, well, there are so many causes of action, judges don't want to hear it. Now, it's very much so the case that if you start discovery, and you do discovery, and new issues arise, and you need further discovery, the courts will then grant a continuance that once you show, look, I've done all this work, there's just this much more to do, then they're going to be inclined to grant that continuance. When you're looking at the courts and you're determining their rules procedurally, you need to look, so if you're in state court, you're going to look to in this order. First you look at the Civil Code of Procedure, then you look at your local rules, and then you look at your courtroom rules. So you're going to have the broad Civil Code of Procedure that governs all of California. Then you're going to have your Los Angeles local. Then you're going to have the California Rules of Court. You're also going to have the California Rules of Court. Then you're going to have your local, Los Angeles County rules versus Ventura County rules. And then you're going to have your own particular issues within that courtroom. Now, the way it controls is the opposite. So the controlling rule is whatever your courtroom has going on, whatever that judge has in that particular courtroom. For instance, in Pomona, in this particular courtroom, the judge on ex partes does not allow oral arguments. He only allows written. So if you come in and you don't have a written opposition, you have to write it in open court with a piece of paper and pen while the cases are being called. That's his courtroom's rules. So you'll learn those as you go. Those are controlling. That controls. If there's any deviation. The next controlling one are the local rules. So Los Angeles County local rules control Los Angeles County. Even if that comes into conflict with the California Rules of Court, the Los Angeles County rules, those local rules, trump. Local rules trump. Courtroom rules trump local rules. Local rules trump statewide rules. And then you have the California Rules of Court that govern. If neither one of these touch on that topic, then you look to the California Rules of Court and the California Rules of Civil Procedure. In federal court, it's very specific. They acknowledge that every courtroom is different, and they have the standing order of that courtroom. The standing order is the judge's rules for that courtroom. His standing order is his rules for his courtroom. That controls if there's any deviation. The next set of rules is the district court rules. So you're going to have the Central District, the Northern District, the Southern District. There's the district court rules. And then, so standing order trumps the district rules. District rules trump the federal rules of civil procedure. But if the standing order and the district courts don't touch on it, then you go to the federal rules of civil procedure. In the bankruptcy court, it's the same. You have the standing order of the bankruptcy court, you have the central, northern, you have the district court rules, and then you have the bankruptcy code. Chapter 7 is a liquidation of the assets. Chapter 7 requires that you sell off all of your assets if you have any equity in your property. So if your client wants to keep their property and they have equity in the property, you do not file a Chapter 7. If you file a Chapter 7, the client's property will be put up for sale, and they will attempt to sell that property off, take the equity, and pay off any of their creditors. The only time you file a Chapter 7 on behalf of a client is when they have no equity in the property and they have no job. They have no income. And now all of their unsecured debt will be discharged. And depending on the court, they will likely be able to retain the property, but when the discharge occurs, the foreclosure will start. A Chapter 13 is a restructuring. A Chapter 11 is also a restructuring. A Chapter 11 is for people whose current debt that they have is over, I believe, 1.13 million or something to that effect. You'd have to look it up. But the point is that at a certain debt limit, there's a limit to how much debt you can have to be in a Chapter 13. If you're over that amount because of your rental property and your primary, or just because of your primary, or because your cars or whatever, if the amount of debt you have altogether when you file your bankruptcy is over a particular amount, over $1 million, then you will find yourself being converted to a Chapter 11 or having to dismiss your bankruptcy. Chapter 13s can be voluntarily dismissed, meaning after you file it, you can get rid of it if you decide to. Chapter 7s cannot be voluntarily dismissed. Chapter 11s cannot be voluntarily dismissed. If you file a Chapter 11 on behalf of somebody, it's extremely complicated. My firm doesn't even handle them. And it can be converted into a Chapter 7. And all of their assets can be sold off. You have to be extremely careful filing bankruptcy for somebody over the debt limit. In general, you have to be cognizant that if you file bankruptcy solely for the idea of stopping the sale, you will get in trouble. There has to be a good faith belief that it is possible there's some way the borrower could restructure their debt to have a viable Chapter 13. Again, it goes back to the standard of good faith. It has to be a good faith filing. It cannot be for the filing cannot be for the sole sake of stopping the sale. You certainly, under no circumstances, would ever want to write out anywhere that that was your intent, if it was your intent, which it shouldn't be. But assuming that no one knows what's going on inside of your head, you don't ever write out that your intent is to stop the sale. That's a product of the filing. But it's just like if somebody, somebody owed money on a car, and you wanted to give them a chance to restructure their debt on the car, but they were coming to repossess the car today, you would file a bankruptcy, so as to give them time again to restructure that debt and catch up on their arrears. So that's really the whole point of a Chapter 13, is so that you can take the arrears that a person owes on their mortgage. You can take that whole number, 100,000, and break it up over 60 months, and you've now given them a figure that's going to be their planned payment. And that's the plan that they have to make that payment in addition to the mortgage payment every month. So now this is extremely counterintuitive to your clients. I couldn't afford the mortgage payment in the first place. I came because I needed a modification. And now you want me to make the mortgage payment that I couldn't afford and an additional payment from all the amounts that I couldn't pay before. Yes, that's what you have to do to have a viable Chapter 13. During that time, you can attempt to negotiate for that modification still. During that time, your client may not make the mortgage payments because they can't afford them. It's not feasible. So they make the planned payments. In that instance, you can get a judge possibly to sign off on the bankruptcy on the premise that they're working on this modification and that somehow the modification is going to allow them to have a feasible plan. I could probably spend the rest of the afternoon talking about bankruptcies and the intricacies involved in bankruptcies, but we didn't really come here for a bankruptcy discussion. So with that overview, we are going to move on. I will say one other thing about bankruptcy in the context of state court, really. That is, when you have a bankruptcy filed, it stops an eviction proceeding. It stops a foreclosure sale. It does not stop you from proceeding in a state court action over title. Debtor cannot have anyone try to collect from him. So debtor stops the credit card agency, stops all entities from being able to collect from it. However, it does not stop debtor from being able to pursue assets that it may have. So the debtor can pursue this litigation because it may be an asset. We found in some bankruptcy courts that the trustee even valued it as an asset. and said, I don't want to abandon my claims. I want you to be my special litigation counsel, and I want you to sue the banks on behalf of the trustee. Because if we get anything from this, I want it to go to the estate, not just the borrower. So it is definitely possible that it can be an asset, this litigation. And so for that reason, because it's an asset and not a liability, it can be pursued on behalf of the debtor. So if they ever try to come back and say, they being the banks, if the banks try to come back and say, we want this litigation stayed, we want this state court action stopped as to title because your client is in bankruptcy, there is absolutely substantial case law to say, no, it does not stop a title action. It only stops an eviction proceeding. It only stops the sale. It only stops the collection of debts. It does not stop the movement towards capitalizing on assets. So yeah, now we can move on. Ooh, looky, we're getting close. Let's see here. I want to leave some time for some questions at the end. So I'm moving a little bit quicker through some of these last topics than otherwise expected. But I do want to give you guys some opportunity to open up the floor to questions. So form analysis. You really want to take it kind of at the time that you're dealing with your cases. At various times, we thought various courts would be more effective. I find that, again, federal courts are extremely open to 1641G, but you'll find that federal courts are less inclined to give TROs. So it really depends on where your case is in terms of how much time you have to negotiate and to get some rulings from the federal courts. The other issues that you'll find, something that you learn through practice, but this is really awesome to know. So if you dismiss a client's case that's the same client against basically the same parties for the same issues, if you dismiss 2 cases without prejudice, the second case is a final decision as to the merits. It's a dismissal with prejudice. So i.e., you file bankruptcy, you file a Chapter 13, Chapter 7, whatever, you file an adversary proceeding. At the motion for relief, when they ask to be let out of the bankruptcy, the court makes it clear to you, you're not going to win your adversary. It shouldn't even be here. I lack jurisdiction. So you dismiss without prejudice your adversary. You then file a federal case, but it could be a state case. Doesn't matter. You file a second case. That case you dismiss with prejudice. That second dismissal acts as a dismissal with prejudice. You cannot then, you can, file a third action in state court and you will get kicked out on preclusionary, res judicata issue. Who would have known? The costs are typically about the same, although the cost may be a little bit lower in federal court because the federal filings are all online, and so you don't incur the filing cost of, say for instance, if you're up north and you have to use a third-party filing services, just throw that out there. I hate Rapid Legal. Don't use them. Use Nationwide. Nationwide is awesome, but they're really good. They care about your filings. And so, we use a third-party filing service, Nationwide, and Nationwide cost more than filing through the federal courts. So, again, the cost may be a little bit higher for your client, something to discuss and consider with your client.
The digital age has closed the gap between information and its accessibility. And it turns out that filing for bankruptcy doesn't have to be as difficult and expensive as it used to be. Introducing Fraud Stoppers, Private Members Association. As a private members association, Fraud Stoppers has helped countless American homeowners achieve financial freedom and the legal remedy they deserve. Fraud Stoppers specializes in cutting-edge foreclosure defense. We offer homeowners state-of-the-art countermeasures to foreclosure with turnkey lawsuit and evidence packages designed to help you get clear and marketable title to your real estate. Fraud Stoppers Private Members Association provides you access to a collection of legal documents and resources that can help you stop a foreclosure sale or eviction, sue your lender for mortgage or foreclosure fraud, get a loan modification, file for bankruptcy, and even fix your credit. So take action right now and get the help you need to save your piece of the American dream.
Strategically, the final decision really has to come down to what you've been seeing in your caseload coming up to that point. So I've been doing a lot of in state court, mainly because it's easier for my team. I mean, the practice of state court is simpler, but the results have not been as positive overall. I still get mod offers, but the best mod offers, the best court results have all come from federal court. And I personally was trained in undergrad I did mock trial for 3 years and got a lot of heavy training, and it was all in federal court. So personally, I feel more comfortable in federal court. That has a lot to do with your final decision. If you don't feel that you know the federal rules of civil procedure, don't go, because you'll find yourself thrown out very quickly. For instance, like, the 21 days you have to file an opposition to the motion to dismiss. On day 20, your case will get kicked out. Versus in state court, on day 15, you might be looking at a continuance because there is some technical problem, or they just don't want to kick your case out. They're going to be more inclined to strike your opposition if they don't like it and they want something else than a federal court is. Federal court, again, just in general, is going to be more strict. The Protecting Tenants Out Foreclosure Act. So backing up and talking about the title issues and then talking about the possession issues. When you're dealing with possession, you may have a tenant in there, or you may have a portion of the property that's been leased out. So what's a bona fide tenant? A bona fide tenant is one who is renting the property for fair market value, who is not the brother, sister, mother, or father of the borrower. Notice I didn't say anything about girlfriend or boyfriend. It lastly has to be an arm's length transaction. So to the extent that it's a boyfriend and girlfriend, and it appears as though they were in cohorts to do this to stop the sale, then you're not going to get past go. I am going to have to take a 5-minute bathroom break now that I drink all this water. There's been a very strong bug going through my office. Everyone, like one by one, has dropped like flies with a sick cold. And so I closed the office last Friday just to ensure I'd be here today. And let's just hope it's not a cold. I just think it's a lot of talking, Most people would say I can talk a lot though. Besides not being an arm's length, it has to be an arm's length transaction, meaning you can't have done it for the sole purpose of stopping the foreclosure sale. It has to be not by, someone who's by blood related to the borrower. Has to be for fair market value. There's been some litigation and some question asked to, is it fair market value of the whole property? Is it fair market value of the room that they're renting? So far, it's fair market. So far in my practice, I found that judges only want to apply it for fair market value of the entire property. And if you just have your client rent out a room, shaky. Although in some instances it has worked. I have also found that it is grounds for removal to federal court if you have a tenant involved. It hasn't ever stayed in federal court, and they give various reasons for why it's not actually a federal question, or it does federal removal doesn't actually apply. But Protecting Tenants Act Foreclosure Act is a federal statute. I do think that it is a federal question. It does require remand, but whether a judge chooses to accept it or not is going to be up to each in particular judge. It was an emergency statute enacted at a time where there was a lot of foreclosures happening. It was meant to, as an emergency statute, cover as many people as possible. And again, that's why it would cover someone who's renting a room versus someone who's renting the entire property. It should protect that person just the same and entitle them to the same things, i.e. that the new owner, this is the question, should the tenant who's renting the room for fair market value of that room be put out and lose his room because the owner stopped paying the mortgage even though the renter was making their rental payments? Or shouldn't the bank have to honor that lease agreement? The last thing is that the lease be entered into before the notice of foreclosure. There was an amendment in 2010 that specified what was a notice of foreclosure. Is it the notice of default? Is it the notice of trustee sale? No, the amendment clarified it's notice of the foreclosure sale, i.e. it's notice of a trustee's deed upon sale. And the reason for that was up until the point where the owner knows that they no longer have a presumption that they own the property, then if they enter into a lease with a tenant, the tenant should be protected. As far as the tenant knows, this is the rightful owner. As far as the owner knows, they're the rightful owner. So it's not as if they fraudulently concealed from the borrower, from the renter, that they no longer own the property, and thereby the renter would have some claims against this prior owner for lying to them. That's not the case. Owner thinks they still own the property. They're not lying. They're not doing anything wrong, and they rent it to the tenant. Tenant then finds out a week later, and owner finds out a week later, owner didn't own it. Well, tenant is still protected because, again, it's a valid bona fide lease if it's entered into prior to the notice of foreclosure. The amendment specifying that the notice of foreclosure is the notice of the trustee's deed upon sale. So now you have your 4 requirements. Prior to the sale, entered in prior to notice of the sale. Usually that's prior to the sale. For fair market value, hopefully of the whole house, and you'll be in a better position. Not a blood relative, and not some scam to just stop the foreclosure, and that's indicated by who the parties are, the terms, stuff like that. If all of those requirements are met, then the person who purchases the property, be it a third party or the bank, as long as they're not planning to live in the property, even if it's a third party, even if there's no lawsuit pending, this is if you get a tenant and you want to help a tenant. This is whether or not the tenant wants to proceed in their rights. These rights are only specific to the tenant. The borrower has no standing to bring these issues to place. If you got a tenant and there's a UD file, you have to file it within 10 days a prejudgment claim of possession. Along with that prejudgment claim of possession, you can file a demur. You do not have to file an answer with it. But you do have to file the prejudgment claim of possession and either an answer or demur with it. Now, once you file the prejudgment claim and you've presented these issues, the final determination that you meet all that criteria makes you a bona fide tenant. And as a bona fide tenant, you're entitled to the new owner first giving you, now there's some question as to whether the first 3 months is free under the Protecting Tenants at Foreclosure Act, or if it just immediately goes into the terms of the lease. But the bottom line is, they have to give you 3 months before they can file an eviction proceeding against you. If you are a bona fide tenant, they have to give you a 90-day notice. So as you can see, tenants have a lot more rights. You can have a property for a lot longer with the tenant's cooperation than you can even perhaps just because of the owner. If a tenant was to file bankruptcy, it has the same automatic stay effect as if it was the owner of the property filing bankruptcy. So, now that you've established you have a bona fide tenancy, you get the benefits of the lease as it was when you had it with the prior owner. So if the lease says that you get to stay in possession for 2 years, and here's the amount of money you're supposed to pay, that's the same amount of rent that you have to pay, and you get it for 2 years. If there's also a clause in there that at the end has an option to buy at fair market value at the time that the lease expires, then you have an option to buy at fair market value at the time the lease expires. Now, it's a term like that coupled with a boyfriend-girlfriend relationship that could make it not look like an arm's length transaction. So that's really important. It's really meant to protect, but a true tenant who actually had a right to purchase a property at fair market value. That's what it's meant to protect. How much latitude it gives you to protect others. It didn't work as well as we would have liked when we were trying to get, borrowers who would get friends to rent from them and they'd give them this option to buy. Courts weren't enforcing it for that reason of that arm's length transaction. Although there was an amendment that said an arm's length transaction really just means as long as it's not your family. So it was kind of the same requirement, but that's not really how the courts are interpreting it. It's really important that you consider any kinds of conflicts of interest, right? The ethical concerns is that you want to consider at any point in your practice, if you're taking on a borrower and someone else is paying for them. Or, this is the one no one ever thinks about. You got two borrowers, husband and wife. You gotta get a conflict of interest. Anytime you're repping more than one person, anytime you're repping and taking money from more than one person in the same transaction, you gotta have a conflict of interest. Because unfortunately, these things can last a year or two, and the guys who loved each other walking in the door, are, a kid going off to college and, another financial investment ruined and ready to divorce by the end. And I literally have cases on my desk where, I've got to tell the client, look, you're telling me to sell the property, you're telling me you want to short sell, you're telling me you want to fight till tooth and nail on a modification, and really what you're telling me is you guys don't even live in the same house anymore, you don't like each other anymore, you guys can't even sit in my office for 10 minutes together anymore. That's when you want to make sure you have a conflict of interest signed, where you clearly can say, I told you at the beginning, that if at any point you guys didn't, currently you both want the same things, currently you both want a modification, you both want to keep the property. That's fine, I can represent you both, there's a potential for conflict. If at some point, like with this one instance, that conflict goes from potential to actual, and you guys actually want both different things, I have the option of either withdrawing from both of you and no longer representing either one of you, or staying with the person who was most in line with the original interest. Frankly, I always choose to get out of both. Because they're coming, no one paying. Or the one that was paying isn't the one I'm repping anymore, I actually would like to take a 2-minute break now. I'm going to go use the restroom, and then we're going to come back and finish the ethics portion, and we're going to have a little brief conclusion with a Q&A. Okay? Hearing no objections? Oh, really? I was going to
I did, and now I'm saying, with format becomes relevant, you have to use a recover at home and see if you can try to get it back. I was going to put the same site
certain amount of lecture to comply with the requirements of the California State Bar Association so we can make sure everybody gets their CLE credit, okay? We're going to go ahead and finish up just with the ethics portion. I think that to a large degree, a lot of the agencies have certainly moved away from their position as to attorneys helping borrowers. It's not as aggressive as it was at one time. There was a big push in 2009, especially to basically scare and intimidate new lawyers from joining into this fight. I think a lot of that has pushed back. There is a Federal Trade Commission for Consumers. They govern to a large degree all of the loan modification stuff now. So Senate Bill 94 that covered foreclosure consultants had a sunset, so it's no longer active, no longer applies. It's been the sunset has set. And so now that what controls is the Federal Trade Commission for Consumers. So anytime you're only doing loan modifications, or anytime you're doing loan modification only, or if you're doing something where you're not litigating, let's just say that. I have another program in the works that is a buyback program basically, and in that buyback program, we don't take funds up front because here's how it works if you do take funds up front for a loan modification. You have to put that money in a trust account, and this is all per the Federal Trade Commission. You must put the money in the trust account. You have to bill off the trust account. You cannot front load So if you take 2,500, let's say you take 4,000, you can't in the first bill 2,500. That's going to be seen as front loading. You cannot try to get all the work done at the beginning or bill for all the work at the beginning so that you can justify taking the money immediately. Secondly, after you've completed X amount of work and you're billing for X amount of hours, you have to submit to the client for approval the hours that you've worked and what you've worked on. Once they've approved, then you can take the funds from the trust account. On the other hand, if you are taking fees deemed earned at the time for litigation, that's different. Again, if you're taking it for litigation or if you're taking for pre-civil litigation, and I described the difference in detail for this reason earlier between just doing a loan mod application for someone and really setting them up for litigation, you can take funds up front for that pre-civil litigation. And it does not need to be put in a trust account, and it does not need to be held in trust as the way I described the other one does. It's really when you contract solely for the purpose of getting a loan modification to the borrower, to the bank, that you're going to need to put the money in trust and bill from it. There's also a spring 2009 Association Ethics hotliner notice, and basically it just says, the normal stuff. Don't fee split, and don't work with a non-lawyer. Don't let a non-lawyer run your firm and do the work of a lawyer, i.e., my intake process is by non-lawyers. My intake process is by non-lawyers, and there's nothing wrong with that. As long as your intake process does not discuss in any way the likelihood of success or the probability of success. If your intake is done by a non-lawyer, then the non-lawyer cannot speak to the probability of success. My agreements have a clause in it that specifically says you've not been told anything about merits or success or probability. In fact, your fees for the first month, you were paying solely for me to review your file, for me to tell you if you have a case, and for me to determine what next recommendations I can give you. It's probably 4 pages of just disclaimers. No guarantees, no guarantees. Say again, no guarantees. I guarantee you, not guarantee you anything. No. There's an arbitration clause in there, and what else do we have in there? There's a conflict of interest portion in there, so if there's 2 borrowers, they can just sign right on this agreement. My conflict check is in there. If there's anybody I've ever had a conflict with that I don't want to work with anybody who's ever worked with them, there's some names that they check off saying they've never had any involvement. It just has everything in there. It has my withdrawal policy. If they don't pay me on time, I will withdraw. They're responsible for cost. They had an opportunity to discuss this with the lawyer. They chose not to discuss this with the lawyer. Check here. If you want to talk to a lawyer, they get set up on a conference call. It's really important that that's in there, that it's been made clear to them that the intake process did not have to be done by a non-lawyer, that was their choice to be, we call it pre-evaluated, basically. Based on that pre-evaluation, my staff has determined that they need assistance. How they're going to be assisted, i.e. with a bankruptcy or litigation, isn't determined until after an attorney reviews the file. Those are really the important key parts, no fee splitting, no unauthorized practice of law. One I found myself in trouble with last year was, you boomed to 160 clients, you got all these people working for you, personally, I'm at 80 clients and in a much better place. Much happier, managing less people, less busy. I'm still making about the same amount that I was making with the larger amount of cases. So you really have, in terms of profit margin, maybe my gross was higher, but with my expenses going up, my margin was about the same. So, from a business perspective, you want to make sure that you're not overextending yourself. Because I managed to not manage a paralegal probably as well as I should have, and he wrote something on a bankruptcy petition that wasn't accurate. Now, I can't say whether he was lying or not because I wasn't inside of his head, and he didn't even work for me anymore when the trustee came back with a motion for sanctions. I take it back, with a motion for a request for disciplinary action, because seemingly it was just a bold-faced lie on the request for dismissal. So I initially explained it by, what had happened in the file. And in all reality, I should have simply said, I don't know what he meant because I didn't write it, and I should have supervised my paralegal better. Ultimately, that's what I ended up saying to the court. Ultimately, it was resolved in my favor, and it was no lasting consequences. But you have to be really, 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 really careful that if you're going to expand to a point where you've got so many cases on your desk, you're not touching everything, that whoever is managing or overseeing the people that you aren't knows exactly what they're doing.
Hi, Esther Goldberg in the sales department to celebrate Fraud Stoppers National Launch. We're having a sale with deep discount prices and special financing offers. We're talking about saving you some serious loot, baby. But I have to warn you, you better hurry because this party won't last forever. So what are you waiting for? A personal invitation? Well, you got it. You're invited. Now, would someone please get me another martini? It's happy hour.
So you're saying I can ask this cat any question?
The cat is connected to the computer. You just type in the question, it will read his mind. There the answer comes.
You're the man! I've been looking for this for weeks.
So I just caution on the ethical side that you want to make sure you're in compliance with all of the rules, and in particular, I can tell you one that you can get in trouble with kind of not even intending on it, is supervision of your staff and of your caseload if you kind of boom at any various point, and that's how the nature of the business goes. You're going to have booms and you're going to have busts, you're going to have booms and you're going to have busts. I would say the industry as a whole, kind of in closing, my remarks would be that seeing familiar faces from earlier this year in January, we're on an upswing, certainly, as an industry. There was a time at which SARs were not very valuable. There was a time at which 2 years ago, I said $3,000 on the retail side, and it was easily $750 to $1,000 on the wholesale side. Then there came a time like last year in January where the case law had just been so bad for so long, the rulings were so bad in bankruptcy court for so long that, I wasn't even sure the SAR had, value above $1,750. Now when Glassgate came back out, SARs are retailing at $3,000 again, easily $3,000. So there's certainly been that upswing with the retail prices of the SARs. Also, as an attorney for the attorneys with the rest reports, it's a great auxiliary product that you can offer your client that, as my business manager terms it, is a second, what do you call it, a second retainer?
Secondary retaining.
A secondary retaining. And secondary retainings, i.e. when a client is already your client, is already paying you for the legal fees, the likelihood that they're going to pay you and want this additional product is very, very, very high. It's much higher than that original retainer of the people walking in the door. So these secondary retainings, the SAR report, the rest report, are very valuable to your bottom line. Also, your margin in terms of how much it costs you versus how much you're charging is going to be higher than your litigation. In fact, in general, on a lot of cases, depending on what you're charging each month, you may be losing money on your cases, and you may have to make it up in contingencies. Now, in that respect, again, we're on an upswing. I can say in this year alone, we certainly, I think you can agree, Rick, have had more cash settlements where we got a percentage of it on our 33% contingency. Because the way my firm does it is a flat fee per month. So let's say that fee is $2,000. And let's say we're charging $200 an hour, which is a very low rate. You're saying pay me for the first 10 hours. On any given file, on any given month, they're going to work anywhere from 25 to 40 hours on that file that month. Obviously, it's going to be your staff as you're paying them. But that means that everything above those 20 hours, we're taking on contingency. Because these cases are so challenging and so difficult to win. If we were successful in getting you a settlement as well, then we would be entitled to 33% of that. So that's kind of how our fee structure works, how we manage the cost of the firm. But certainly, if it's if they're paying $2,000 and it's taking me 30 hours, then I'm not making a profit on that particular case in that particular month. But overall, if you do a bulk business with that model, you will find the margin is very high. You know, we probably gross around 100K a month, and you know, we probably, you know, our costs are somewhere in the range of 50 or 60K a month. With that being said, the firm during that peak time took on a lot of debt. So although our current cost is probably only 50 or 60, when you add in the debt, our margin is probably closer to 10 to 15,000. So that matters too. You know, I can say from the business experience, when you do boom, be willing to let go of it when it's not booming anymore. You gotta let go of people. You may have to downsize again, and you shouldn't be so tied to staying one size that you lose money in the process. Again, in closing, we really are in an upswing. The case law is going to continue to change until we have a definitive answer from the California Supreme Court as to securitization. It is very much so alive and well, and we will very much so continue to build cases into the minority. And again, we're encouraged to have a minority. And it's all of us in here that brought Herrera, that brought Glaske. It's all of us in here that bring Jenkins and the other cases. You've got to just keep the fight going to really see who's going to come out the victor. And the bottom line is, while you're in the fight, even if we don't win the war, we've saved so many lives and so many casualties have been avoided by the battles that we've all participated in. So keep up the good fight, and I'm absolutely here to answer questions. I will probably keep it to about 4:15, and then I'll cut off the questions, okay? But that gives us a good 40 minutes. I think that should be enough. We're going to go ahead and, just to make it fair for everybody, I'll work around the room. So I'll start from the front to the back and come back, and then I'll do the same again. So do we have any questions in the front row?
Yeah, in the audits I do, I always include the
Can we talk really loud so I can hear you over everything? Yeah.
In the audits that I do, I always include the modification clause for the PSA agreement, which restricts the ability of the borrower to get a modification. Can that represent a change in the original deed of trust contract, unilateral change in the original deed of trust contract, the fact that they changed the terms of it for the restriction of modification?
I don't think so, because again, the pooling and servicing agreement does not include the borrower. So technically it hasn't changed the terms of the original agreement with the borrower. They've just now put themselves in a position where to comply with the original agreement, they have to break the agreement that they made with the investor, or vice versa. They have to either reach the agreement with the investor and keep their agreement with the borrower, or reach their agreement with the borrower and keep it with the investor. The fact that they've signed two in opposite contracts doesn't rise to a cause of action.
Quick question. You talk briefly about the Jenkins case. It's a Glaske is a minority. Jenkins has got a reason. How do we address that when the justice of the panel talk about it?
Sure. What's really actually quite interesting about Jenkins, okay, and all these cases for the defense side, is the defense will win a case like Gomes. Okay, Gomes had nothing to say about securitization. Right. Nothing. It was about MERS. But let the defense tell it. That case was absolutely, you cannot sue over securitization. Jenkins doesn't have anything to do with what Glaske talked about. Jenkins doesn't apply. Jenkins is a completely different issue. Jenkins went to the issue of whether or not WAMU's transfer to Chase allowed Chase certain rights under the assumption agreement. That's what Jenkins had to do with. And, I'm sure there's more, to Jenkins than I probably want to agree with, but I'm sure there's less than what the defendants. I know for a fact that Jenkins in no way dealt with closing date of the loan. That just simply wasn't, it didn't address whether or not the assignment, whether or not they were allowed to argue against it even though they weren't a party. Okay, it doesn't, it touches on a lot of the same issues as Gomes, and it simply doesn't apply to the case the way Glaske does. Jenkins can be distinguished in that I think the issues that the opinion just simply did not address the issue of the closing date. I don't think it even got to the issue of the closing date. It was a step before that. It simply said New York trust law doesn't matter in California is basically how Jenkins came out. I mean, it's not a good ruling for us. There's no question that it's, it's not in favor of the borrower. Certainly that can be gleaned from the ruling. Does it specifically address closing date? No. And so ruling in favor of Glassky does not rule against Jenkins. They were talking about two different things.
Do you have the assumption agreement from that case in discovery, the one with the chase assumption, the whole goal?
No, we didn't get to discovery. And I'll tell you, one of the things in that very well may be that we filed a motion for recusal against that judge in Orange County. And so, you know, I'm not surprised by how it came out. I certainly don't think it had anything to do with my practice. At the time, I had a young woman working for me, Kathy Morozova. She now works for an entertainment law firm. That's what she wanted to do her whole life. The best writer I have ever seen in my practice on either side of the fence. Actually, one of the group members today worked with us at one time as well, and she had the opportunity of working with Kathy and can tell you, I mean, her writing is fantastic. I mean, her written ability to articulate the concepts that I've said here today verbally is superb. They simply disagree. They disagree with the borrower's right to challenge the bank's ability to foreclose, and that's what that opinion stands for. And so it's really a matter of distinguishing on the facts and distinguishing that they do not directly deal with the closing date.
What does a typical settlement look like, and how often are these settlements obtained?
Very hard to say typical. I don't know that there's an average, but if I could give one, it typically results in a loan modification with some interest rate reduction and thereby a lower payment. That's usually the end result. Now, everything varies from there. You can get some that have better modification offers, some that have worse, some a good modification offer and cash, some in with them foreclosing and having to do a cash for keys or resolving. So it just runs the gamut. So I'm on this consumer-focused fraud group, mortgage group, Yahoo group. It's about the 20 most premier lawyers in this area of practice. A friend of mine got me involved. His name is Norberto Reyes. He was in it for a very long time. And the guy who did the appeal on Glassky is part of the group. And so I actually knew about Glassky before Glassky even hit the mainstream stuff because he had already been posting it and talked about it because it was his win. They put a lot of the information out that I'm familiar with, a lot of the case law I get, a lot of the information I get, I'm able to obtain from them. And my sense is that they're all getting about the same things, we're getting some, again, I'm getting somewhere between 4 and 5 mod offers a week. They're not always agreeable. This is what I was going to say. I read on one of the posts at one time, although I didn't have a lot of time to kind of really delve into it, and I've kind of always gotten this sense. So my understanding from that post was each property, is fought over more or less based on behind the scenes criminality. There's a lot of criminal stuff, like we're not just talking civil violations of statutes, but criminal activity going on with various loans, various properties. How much more or less criminal activity is associated with any one property ends up being the result, the reason why some properties are easily modified and other ones are not. That's my understanding.
How do you discover those?
Again, I didn't get a lot of time to read into it. I didn't see a lot of value in trying to figure out that aspect of it. I'm not sure that it will matter ultimately. If you could figure out which one had more criminal aspects to it than others, whether or not that would ultimately result in you being able to get a better or worse modification. But it just was kind of interesting because I think it goes to say that all of us in this circle of foreclosure attorneys have the same experience of one being able to modify and one not. I mean, it was certainly speaking to that. We certainly all agreed on that's an ongoing experience, that some are easily modified and others absolutely you can't get it done. Why is that the case? And there was this article from one of the members saying basically some have criminality behind it and others don't. I suppose getting a PI, but it's really hard, to get, especially if it's Fannie or Freddie one, in that they're not in the public record. So you're even more masked. But really just going forward with the litigation, getting a good judge, getting into discovery can really open up those windows of information. The next.
I'll let you think.
Hey,
action where there's a securitization. It's been transferred to, say, New York Bank Mellon as the trustee for the trust. And the assignment was done to, say, Bank of America, and Bank of America is now doing the foreclosure. What are the 15 things you might go to look for in terms of production of documents and interrogatories and things like that?
Well, anytime I do a production of documents, I do a pretty big broad, I want any and all communications between Bank of New York of Mellon and so if it's to Bank of New York of Mellon, I want any and all communications to Bank of America. I want any and all communications to every defendant. I want any and all documents that you have to every defendant. I want any and all communications with the plaintiff. That's a difficult question. I would prefer if you could get one of my business cards. I can email you a sample of what we do. That's a lot easier.
Super. That would be great.
Yeah,
That would help
and
a lot.
I'm really about the free flow of information. To the extent that I'm able to help other people, they're able to help the industry. We're able to get the case law that we need. It always helps my clients. To the extent that you need additional, time on the phone with me, maybe that's something that needs to be compensated. But free flow of information for sure. By all means, that I certainly share those discovery requests.
Okay, you mentioned the Yahoo Law Group.
Yeah, that I'm not privy to let other people on. I can give you a contact name for the person who it's Walter. I don't remember his last name right now, but I can direct you to the person whose group it is, and then you can discuss with him joining the group.
Thank you.
Have you been able to get that information from Discovery? All the communication?
Yeah, I mean, it depends on the situation. Sometimes they'll object, they'll object to your discovery, then you have to do meet and confers. But yeah, I mean, it depends on how far you get with the judge, how far you get into litigation. But ultimately, if you're going to go to trial, you have to get that. And you're entitled to it. So, I mean, it's a motion to compel after that. Any questions?
Yeah, can I give Courtney my next one?
You
My
go
question?
ahead. You ask. We'll get back around.
No.
No, I'd like to give Courtney my
Oh, you want him to ask another question
Yeah,
for you?
please.
Sure, by all means.
You're settling most of your cases in loan modifications. Are you doing very much in the way of clients who may be rental properties or something like that, so they're really not interested in doing the loan modification? They're more interested in, my experience has been, if they ask to make a deal, they're going to come back and want you to pay off a certain amount, as opposed to loan modification.
It depends on the very particular circumstances. The difference between it being a rental property and primary residence has not changed the results of the litigation much. Typically, they're looking for a modification. They're looking to keep the property at modified terms, even if it's a rental property. So I haven't seen a lot of varying results based on that variable. There are so many variables that go into what loan mod you get if you get one, that I can say income expenses is definitely more of a factor than it being rental versus primary.
What about the fact that in your securitized audit, and I am qualified that way, in the securitized audit where it shows that so many of the tranches have been paid off, have you been able to determine how much is actually paid off in those tranches and get that kind of credit on your loan?
Well, okay, so I tried that for about half a year, and judges didn't believe it. They just didn't let me get past the demur stage to really do discovery to show how much of the tranches. Because we were saying, look, this Bloomberg audit shows that not only has the originator, the sponsor, the depositor been paid, but now the investor's been paid too. And if the investor's been paid by credit default swaps or insurance, okay, then the only person standing to lose any money if you take this property is the borrower. Basically, tender isn't necessary. Tender has already occurred via a third party. It didn't work. It got us, past a certain point in the litigation, but I never got that issue to go to trial.
Even in federal court, that didn't work?
No, it didn't work. Tried in the federal landscape.
I have several questions, but I think they're pretty straightforward, and hopefully we'll take just a couple minutes.
Sure. Can you just talk a little louder? So
Do you ever do list penance on bank owned? I usually do, just to keep them from not selling to a third.
Yes, I do.
Okay. And
Always. If there's a lawsuit pending, I absolutely record the list penance.
I know they squawk with bank owned. We usually hear a squawk, but and they want us to remove it, but.
Well, yeah, they want you to remove it anytime they'll file a motion to expunge, or they'll send you a letter saying you shouldn't do this, and that's all well and fine, and you just send it back saying,
Oh, well.
give me a second, let me take your question and then we'll come back.
What about quiet title? Do you ever use that cause of action?
That absolutely triggers tender because it's a cause of action in equity. So it's an equity court. So then the issue of equity, not equity in terms of like how much value does this property have, equity in terms of fairness. It's an equal. Quiet title is considered to be a cause of action in fairness, in equity. And if it's in fairness, in equity, courts always invoke the tender rule. So I've sued for it before, especially when clients are just absolutely attached to it. Clients very much so have the idea that quiet title is the way to go and will win. So sure, I've tried it, it's never worked.
I saw it on Glassky too, that they had quiet title on that.
Yeah, I mean, and they had a whole bunch of causes of action that seemingly got through, so.
So what title do you do then? You don't do quiet title, you say.
I do wrongful foreclosure and sometimes declaratory relief, a violation of 2924A. And it always depends on the particular circumstances. But another thing that was really beneficial with the Glassky court, I lost the thought.
The tender was what was beneficial. That's what you were going to say, because that's what you were just talking about with tender.
Yeah.
And Glassky. That's how they got
Well, it was
around
tender on Glassky with part of it, but then if there was quiet title, they had quiet title in there too.
Right.
But they got around the tender because of the void.
Right, they said that tender didn't apply. Oh, this is what I was going to say about Glassky. Here's what's really key to understand about Glassky is that it was at the pleading stage, right? So let's all remember that the Glassky decision wasn't saying you win all these things at trial. They were simply saying you've pled enough that you get past the demur stage. So I just want to reemphasize that.
Okay, and then 2923.55, that's the new.
Say it again.
2923.55 takes the place of 2923.5. Now we can request the servicer some documents similar to the QWR. Which one do you feel is stronger, the QWR request or the 2923.55 request?
Definitely 292355 request. And that's because you can get a whole cause of action from that, where you get everything you want. Whereas RESPA and TILA, first of all, they probably have longer to respond to those, the timing wise too. And also, you're stuck to $4,000 in statutory damages and attorney's fees and costs, whereas you're not wedged to that under a civil code of procedure violation. Your damages are bigger under the CCP violation than they are under the RESPA violation.
Do you think that I noticed that they're changing servicers while in litigation? Do you think that's a ploy, or do you think that's just?
Oh, that's absolutely meant to take out the servicer from the litigation. It's absolutely they're doing that very much so on purpose, and it's very much so to take out the servicer from the litigation. And it's also because when you're in loan mod review, if you transfer servicing rights, there's some argument that the new servicer is under no obligation to pick up where the servicer left off.
Okay, which brings me to you talked about the law that the courts are not looking at the and we've had that ruling too, where the homeowners bill of rights is only they'll say it's on the notice of default, which happened in 2012. They're not bringing that over to 2013, even though the foreclosure is not finished. But then I did see up on the Homeowner Bill of Rights Collaborative, there's some new case law. And there is a case law that does direct that is saying that we're only talking about the notice of trustee sale. We're not talking about the notice of default.
I mean, I think it's going to be discretionary until we have some Court of Appeals case law that says retroactive, no, it applies from this date to this document.
There may be Civil Code 3, which says no law can be retroactive.
Right. I mean, there's no argument by our side that it's retroactive. Our argument is that it's not occurring until 2013. There's going to be some case law by the Court of Appeals that says, if it starts in 2012 with an NOD, then it occurred in 2012. If it ends in 2013 with a trustee sale, then it's applicable. We don't have any Court of Appeals case law. I mean, I understand that there may be some on the collaborative, there may be some lower level decisions, but I'm not aware of any directly on point Court of Appeals cases to that issue.
Okay, that's it.
Any question? Gentlemen? Okay, we'll start on this side and work this way, okay? Go.
First, okay, when it comes to getting damages, in my documents, I'm a homeowner, I can see robo-signing, the B and C or just one scribble, and then I see like on the notary, it's done in different locations, so like it was witnessed by that. But you mentioned there's fixed damages for those.
It's not that there's fixed damages, it's that you have to have actual damages for those. So you have to show how that actually hurt you. Like, how did that hurt you versus just your inability to pay for the loan? That's their argument, is even if that hadn't happened, would you still have been able to pay for the loan? If that's true, then it's a problem that they did it, because, you know, even if you could have paid for the loan, so for instance, RoboSigner signs something and it means that now when you send your payments in, they're not accepting them anymore. That would be directly because of her signing that. You see how that's just not the case. It's very hard to show that the robo-signing actually is the reason why the value of your property decreased. And that's what you would want to show. You would want to show that these fraudulently recorded documents, that these documents that are not real, that don't really show what's really going on, have major title unmarketable. Now, if you can get an expert witness, as we have previously from CFLA, to come in and say, look, if there hadn't been this fraudulent assignment, if there hadn't been this fraudulent notice of default, the property would have been increased in value by $40,000. That's a damage. That's an aspect. The title isn't marketable, and then you get an expert to come in and say, yeah, we can't give this title insurance because, for instance, at a time, Fidelity National Company came out and said, all the title companies came out and said, we will no longer insure Gene Mack mortgages. They've just screwed the titles up so much, we won't even insure those anymore. That's clearly damaging to your title.
Okay, it's me. I have two questions.
Sure.
The first one, I have a client that his house was sold at sale to Fannie Mae, and now Fannie Mae, there's an agent coming around and saying, I represent Fannie Mae and going into rent.
Okay.
So that's a situation where Fannie Mae is accredited as the investor, even though Fannie Mae doesn't actually is not the investor.
Okay.
I don't understand that. I mean, can you?
So I mean, that's a wrongful foreclosure. It's that's definitely a claim for wrongful foreclosure, that the wrong entity is the non-beneficiary is coming in and trying to foreclose. The other one we've tried against that one is fraud upon the court, because I'm sure in the trustee's deed upon sale it says Fannie Mae paid $230,000. Fannie Mae is in receivership. They don't have any funds to be paying anything. So when you want to get in discovery, you want to request any type of wire transfers from Fannie Mae to whoever the prior owner was. Because Fannie Mae is representing on that trustee's deed upon sale that it has purchased this property for X amount of dollars. So there has to be some record of that money going. Otherwise, it's just a bold-faced lie. I mean, that it just never happened. You just wrote up some document saying it happened and it never happened. In that case, the judge ruled that we didn't have standing to bring the issue of fraud upon the court. If anybody should be concerned about it, it was the court, and they weren't. It's something worth trying.
But it's different now because of last. Okay. And the second question, this is your 2924A6.
Yeah.
Okay, the correct beneficiary has to be the one that's doing not just the foreclosure, but the assignments as well, right?
No, 2424A just speaks to who's foreclosing.
Okay, because I have a situation where the assignments are recorded from the servicers, and they're claiming to be the beneficiaries. So I tried to call that, and I've been still in court on this, tried to call that wrongful foreclosure in violation of 2924A6 because Bank of America is assigning to NationStar as if they were both beneficiaries. But
well, yeah, but neither one of them. If neither one of them are beneficiaries and they're solely the servicer, then that's a violation of 2924A.
Yeah. Okay, because the bank attorney is saying no, they are the beneficiaries, but how can they be?
Well, I mean, you can be the servicer and the beneficiary. There's nothing precluding you from being both. You can service your own loan. You can service your own loan, but you have to have the paperwork correct for you to service your own loan.
Right, I
So-
have them audited, they're not.
Right, so I mean, that's the simple, right, I mean, in this day and age, it's rare, but it can occur where Bank of America buys a loan, originates a loan, services the loan, and chooses to stay, or there could be an instance where Bank of America services the loan, and it later on becomes a trustee of the securitized trust. That you have to realize there are two different entities. That's Bank of America N.A., and that's Bank of America as trustee for Securitized Trust X. Those are two separate entities. One is the servicer, one is the investor. Now, you could have Bank of N.A. As a servicer, and you could have them as the original lender, and in which case you'd have the same entity. But you're never going to have the same investor entity as the servicer, because the investor entity is always going to be a trustee on behalf of a securitized trust, which will never be a servicer.
Right.
They can't.
In that case, it's also, that's a Freddie Mac, which is, as you mentioned, blocked from any kind of information, but you do know that it's Freddie Mac. You know that it's not Bank of America that's the beneficiary.
Right, and so they're just mistaken in what a beneficial interest is, and this is a lot of issues that go to trial. What's a beneficial interest versus what's not a beneficial interest, That's a lot of the defense when they get down to the merits. They'll say, oh, it's not a 1641G violation because we weren't transferring, this isn't a new owner, we weren't transferring all the beneficial interest. Well, look at the assignment. The assignment says transferring all beneficial interest. Right, so you just have to look to the language of the assignment, and you have to look to any other indicators you have in your file, as well as the standard terminology and understanding one has in the industry. You get this from an expert as to what a beneficial interest is.
A couple different questions. One of them is, what do you think about suing attorneys who represent the banks? For example, in a bankruptcy case, go in and file a proof of claim, claiming, Your Honor, we have, no, they file a proof of claim, sign their names as the attorney for One West in this case.
Hey everyone! Are you looking to sue your bank for mortgage fraud or foreclosure fraud? If so, you should call Fraud Stoppers right now, because we'll show you a proven way to help you save time and money and increase your odds of success, getting the legal remedy that you deserve. Remember, when the banks break the law, we break the banks. So call us today.